Subsequently, the second appeal was dismissed. The execution proceeding started there in the lower court. During pendency of the execution proceeding in lower court, in local law, that was settled and the claimant, they have taken back their money. But our money, that is 50%, that is pending. Or direction to the registry to release the amount in our favor for order also.
Case admission, transfer question, criminal one.
But second appeal, there is an application for injunction. Actually, 3 acres of land is lying vacant. Nobody is allowed to cultivate the land. There is scramble of position, have had an application for injunction.
Yes. Supplementary list item number 1.
My lord.
Sir.
My lord, may it please your lordship, my lord.
Yes.
My lord, in this case, your lordship.
Physically present?
In this case, your lordship.
Where is physically present, Mr. Mishra?
My lord, personal difficulties I have got, my lord. To date.
Yes.
In this case, your lordship directed yesterday that along with these 2 matters will come. One
Yes.
matter has come, another matter is TRP C number 273 by 2019.
Let it come tomorrow then. Along with that.
TRP C number 273 by 2019.
List these matters tomorrow along with TRPC number
273 by 2019.
273 of 2009. Yes.
Obliged.
Yes. Item number 2.
In this case, my humble prayer, the transfer of this matter of mat case from Banki Court to Provincial Court.
Yes.
And because before that, since 2022, there is a one CRP number 248/222 regarding maintenance is pending in the Provincial Family Court. The petitioner, the husband is not coming there. I am the wife of the case. My lord,
Notice to the opposite party by speed post. Fixing a short double date, requisites be filed by tomorrow. Peremptorily list this matter on
7th August.
7th August. Yes. If any application for adjournment is moved by the petitioner in the court below, the same shall be considered, having due regard to the date fixed for hearing of this case.
my humble prayer, that just 1 month their marriage was there. So if they may be called to for a to our mediation center appear.
I have issued a notice, let him appear. Yes.
Item number 3.
May I lordship.
Yes.
But in this case, my lord, the petitioner had previously approved before this honorable court in WPC number 9325 of 2023. And there was a direction for consideration of his repentation.
No.
And thereafter, since non-consideration of the repentation was there, he filed one content petition. And that content petition, as it was treated, my lord, as the first contempt, some more time was granted and it was disposed of. Then he filed a second contempt. And till that, my lord, no notice has been issued in that second contempt. But I was directed to take the instruction about the fate of that particular repentation. On 2/2/2024, order has been passed and it has been dismissed, rejected.
2/2/2024.
I am handing over a copy.
Give a copy
Also,
to
my lord,
so that he can challenge it if he wants.
Yes, sir.
Then State Council has obtained written instructions to the effect that the representation of the petitioner, which is directed to be considered and disposed of by this court in an earlier writ application filed by the petitioner, being WPC number 9325 of 2023, has in the meantime been rejected as per order dated 2/2/2023.
24, madam.
23 लिखा है। They signed it on 2023.
My lord, it is a
2024
24.
bracket रे, wrongly signed by the Commissioner cum Secretary
On 2/2.
as 2/2/2023 as submitted by Leonard State Council. Bracket closes. Stop. Get a copy of the order of rejection be served upon the petitioner who appears in person. So I think what is your prayer here?
Since this matter was pending according to him, my lord, and in the meantime, your lordship disposed of that case of preference in Mamta.
Anyway, you have to a writ petition तो आपन को जेतु एटा रिजेक्ट हे गलानी आ एटा को तो देखिबनी you have to challenge this.
So
एटा challenge करिया
you
पड़ो.
may be permitted to withdraw to dispute the same in the light of the next case.
ममता नायक
Mamta Naik case जो preferences जो ट्रीटमेंट पे दिया इतला first preference, second preference, third preference. He is seeking a parity with that particular.
But how will it help him? When he
is
has to
also-
challenge it.
He is also claiming that he is also.
No, he has to challenge this before this court.
That is what, my lord, I am submitting. That he may be permitted to withdraw this one so that he can file, sell the order dated 2/2/2024.
Now that it has come to his knowledge, he can amend his writ application also. Please amend your writ application.
No pleasure.
The petitioner requests for some time to make his submissions in the matter. List this case on the
14th August.
14th August 2024.
Next week,
Next week week.
next week ମୁଁ ଟିକେ ପୁଣି ଡ୍ୟୁଟି ପଳେଇଲି ପୁଣି ଯୋଉଠି ରହିଛି ପଳେଇଲେ ଅସୁବିଧା 3-4 ଦିନ next week ଆସ ସୋମବାର
Next week. List this matter next week.
ମଣ୍ଡେରେ ଟ୍ୟୁଜଡେ ଆସୁନ
ନା ଆମର ଆଜି ଯୋଉ ଦିନ ଆସିଛି ସେ ଆର ୱିକରେ ସେଇ ଦିନ ଆସିବ 18 ତାରିଖ ଆସିବ 18 ତାରିଖ ଆସିବ you go through that and find out what to do. Yes.
I don't know for
May I please, Lordship?
Yes.
It is a case, Lordship. The action of the opposite party number 1, not taking any steps to dispose of the representation. The applicant annexure 5, taking into consideration the guidelines annexure 4 and 5, Lordship.
What is the
Case was that the petitioner joined in the Anganwadi worker under annexure 2, Lordship, 7 to 2010, Lordship. Thereafter, he is passing the bachelor degree and SCW, that is certificates of 3 series, Lordship, that is page 15 to 17, Lordship. Guidelines, annexure 4, page 18, 15 September 2015, 3(1), Lordship. The 50% of vacancies in the post of supervisors would be filled up by promotion from amongst Anganwadi workers within 10 years of experience and Anganwadi workers having the prescribed educational qualification. He is the, as per the recruitment rules, he is the qualified, the eligible qualification is there, Lordship. Thereafter, Lordship, annexure 6, Lordship, page 21, 1st August 2022. That is the page, running page 23, Lordship. Paragraph 3.2, column B. 50% of supervisors shall be filled up by promotion of Anganwadi worker with 5 years of experience subject to availability of vacancies having the prescribed educational qualification as per the recruitment rules for the post of supervisor, filing which the vacancies will be filled up by direct recruitment, Lordship. This present petition was made representation to the Government of India, that is the Secretary, Minister of Women, Lordship, on 6/4/2024, Lordship. As because 2 posts has been vacant in Bed and Block, Lordship. Annexure 7, that has been forwarded to the opposite party number 1, dated 30th April 2024. My case has not been considered, Lordship. Only case for consideration of the promotion to the post of supervisor, Lordship. I have been educational qualification as per the required recruitment rules. I have
Yes.
I have no objection. The only thing, my lord, he has relied upon all the central government notifications and other things, my lord, and to govern this particular field with respect to recruitment to the post of the Anganwadi supervisor, there is a recruitment rule, my lord, in Odisha. Statutory rule is there. The Odisha Children's and Women Welfare Service Recruitment and Condition Service Rule 1999. Their collector is the appointing authority.
Yes.
So
does it not provide for promotion?
yes,
It provides for
there is a provision for promotion through selection from the Anganwadi workers who are otherwise eligible.
Your Lordship, as per the annexure 4 and 6, Your Lordship, all secretary dealing with ICDs in status.
No, 4 and 6 will not override the statutory rule. Whatever is there in the statutory rule, if you have to be considered within the ambit of the rules.
Yes, sir. Ambit of the rules, because they have codified that is if vacancies there 10%, that is 10 years experience. That now
Yeah, that's all right. That's all right. I'm not saying that you will not be eligible under the rules, but the only thing is that it has to be considered within the rules.
Yes, sir.
It has to be considered. Yes, Mr. Bhatt.
Yes.
Yeah. The petitioner has approached this court with the following prayer. The facts of the case are that the petitioner has been working as Anganwadi worker in Khaliapalli, Directorate M, Anganwadi Center, under Arjunda sector,
Yes, sir.
since 7/2/2010. She claims to possess Bachelor of Arts degree. Stop. As per the guidelines issued by the Government of India in Ministry of Women and Child Development Department, Child Development, development regarding recruitment of supervisors under the ICDS scheme, 50% of the vacancies in the posts of supervisors are to be filled up by promotion from amongst Anganwadi workers having 10 years experience as such. Further, the operational guidelines for implementation of Saksham Anganwadi and Poshan 2.0 also provides that 50% of the posts shall be filled up by promotion of Anganwadi workers with 5 years of experience. So, the petitioner submitted representation addressed to the Ministry of Women and Child Development, Government of India on 12/4/2024 for consideration of her case for promotion as per the guidelines. Said representation has been forwarded to the Principal Secretary to the government in the Department of Women and Child Development and Mission Shakti by the Ministry of Women and Child Development Department in its letter dated 30/4/2020. The petitioner has also submit 6/4.
6/4 that has been it will be that is 12/4. They have accepted in 12/4.
6/4. So this representation is prior to the issuance of the Government of India letter. So we will not refer to it. We will simply say it is pending with the government. Government will consider upon. Let's take counsel. Yes.
Because the competent authority is here, the collector. And with respect to the petitioner, the collector is the.
No, but her grievance has been forwarded to the Principal Secretary. So we can direct the Principal Secretary to take a decision or to depute to relegate it to the collector.
Yes.
Correct. Since the grievance has been forwarded to the Principal Secretary, the writ application is disposed of, directing him to consider the grievance of the petitioner. Let the Principal Secretary decide what is wrong.
Yes, yes.
Let to consider the petitioner as forwarded by the Ministry of Women and Child Development Department and dispose of the same in accordance with law within a period of 2 months from the date of production of certified copy of this order by the petitioner.
Urgent copy also.
Urgent copy.
Okay.
Item number 5.
Madam, I am from VC Miller.
Yes.
Madam, the petitioner is a physical handicapped lady. She wanted to give one document on the affidavit, but she could not able to come today, Miller. But at least Miller, it may come to next week, Miller, so that the matter will be disposed of. Next week or 1 week after.
All right, since the reply and counsel for the petitioner requests for adjournment on the ground that the petitioner is required to file, is required to
Additional
affidavit. Is required to file an additional affidavit. Stop. This is matter. 24 on 24 July. Affidavit, if any, be filed in the meantime.
Public.
Item number 6.
My beg of Lordship, pardon, Lord.
Yes.
This matter, Lord. Yesterday, I have demonstrated
how the OP number 2 has made deception to get into admission in the Madhyama school and managed to get the admission and obtain the Madhyama certificate equivalent to matriculation. Thereafter, he got up. That is my humble submission. And my lord, having said so, my lord, when the edifice erodes, out the edifice, and the castle, however strong that might be, it bound to get collapsed. That is my basic main theme of the argument. That means, my lord, the opposite part number 10 does not have elementary education. OP number 10 is the contesting opposite party.
All right, the ADM has not taken into account the information you have obtained from the institution.
OP number 10.
So let him, yes. The opposite party doesn't appear. Yesterday also there was no appearance, so the matter was adjourned. Is there order sheet account lekha hai dekh lo?
Notice duly served.
Well, dispose.
Yes.
It
We
is
have
a-
not filed any counter, but I can rely upon the Annexure 6 melody.
No, I was yesterday I was going through the appeal memo. That is why I had asked Mr. Das whether the
Yes.
so under paragraph 2 he has taken a specific stand
Hon'Ble.
of that appeal memo. That has not been considered by the ADM.
My lord, my read petition melody, it is up to Annexure 6, page note 22. I think the appeal
Abun
memo
dehi na
is
dinu.
subsequently added. That has not been provided to me.
By through amendment, I brought
Set up the
It is a copy देना.
it.
So he has taken a specific stand
Yes.
that he has created a false school living certificate and all that. All right. So we'll dispose of.
Yes.
The petitioner has approached this court with the following prayer. The facts of the case are that कि भाई advertisement के वाला
Advertisement. Annexure 1 below.
pursuant to an advertisement कोर्ट आ गया advertisement
Annexure 1.
advertisement annexure 1 is something else.
No, the application form.
I'm asking for the advertisement. Pursuant to an
I
advertisement.
need 16.
Sir, sir.
Notification number
Sir.
in my para 1.
Sir, it's all right. Pursuant to an advertisement issued by the CDPO Mahakalpada for engagement of Anganwadi worker in Gojobandha Center on 9/8/2016, the petitioner submitted her application. The opposite party number 10 was also an applicant. In the selection committee meeting held on 24/9/2016, the name of opposite party number 2 found place at serial number 2. However, she was selected for engagement. Subsequently, shortly thereafter, the petitioner came to know from reliable sources that the opposite party number 10 had submitted forged and manufactured educational certificates showing her to have passed class 7 from Netaji
Yes.
UP School, Kumarpada. On such basis, she took admission in Ma Vajrabudhi Sanskrit Vidyapitha, Kumarpada, from where she passed her matriculation examination. However, as per information obtained by the petitioner from the headmaster of Netaji UP School under the Right to Information Act, it came to light that the petitioner was never a student. The opposite party number 10 was never a student of that institution. Stop. Accordingly, the petitioner preferred appeal before the ADM Kendrapada, being Anganwadi appeal number 5 of 2017. Stop. Specifically, taking the following plea, specifically, specifically pleading as under in paragraph 2. Record appeal member. The ADM, however, in his order dated 15/2/2018, he referred to the documents filed by the parties and found that the present opposite party number 10 had secured the highest marks and the petitioner the second highest marks. Further, the CDPO Mahakalpada obtained copies of HSC and +2 certificates from the concerned organizations and produced before the ADM. On such basis, the appeal of the petitioner was found to be without merit and was dismissed. Sri B.S. Das, Bhavani Shankar Das, learned counsel for the petitioner. Third, Sri B.S. Das, learned counsel for the petitioner. Sri S.N. Patnaik, learned AGA for the state. Stop. None appears on repeated calls for opposite party number 10. Yesterday also there was no appearance. Yesterday also there was no appearance from the opposite party number 10 despite repeated calls. Stop. As such, the writ application is taken up for hearing. The writ application is taken up for hearing. Sri B.S. Das, learned counsel for the petitioner, would submit that if the very basis is fraudulent, the entire edifice built upon it cannot be sustained. Stop. He submits that when the petitioner produced a forged certificate showing her to have passed class 7th, the same implies that all subsequent academic qualifications that she acquired would have no force of law. As an act of fraud cannot be validated subsequently. Stop. Sridas would further argue that despite such plea being specifically stated as taken, the ADM did not consider the same and was apparently swayed away by the subsequent educational certificates. Stop. Sri S.N. Patnaik, learned State Counsel, would submit that, would fairly submit that all the grounds raised by the petitioner in her appeal ought to have been considered by the ADM in accordance with law. Stop. Having regard to the rival submissions and the materials on record, and particularly the ground taken by and the materials on record, this court on perusal of this court finds that the impugned order does not deal with the ground taken by the petitioner under paragraph 2 of her appeal memo. Stop.
Appeal.
Thank you.
Under such circumstances, the appeal cannot be treated to have been, cannot be said to have been correctly decided. Properly decided, as the ground raised by the petitioner can have a material bearing on the final outcome. Stop. In such view of the matter, the writ application is disposed of, remitting the matter to the ADM Kendrapada to rehear Anganwadi appeal number 5 of 2017, considering all the points, all the grounds raised by the parties after giving them opportunity of hearing. Stop. The ADM shall do well to dispose of the appeal in accordance with law as early as possible, preferably within a period of 2 months. 2 months. 2 months from the date of production of certified copy of this order.
Urgent.
Item number 7.
Urgent copy.
It's a case where the present applicant, present petitioner, she has engaged in the year 2010, continued forever.
Concern filed.
Counterfeit.
Yes,
Concern
counter
filed.
filed. Your lordship had directed to produce the records. Now the CDPO reports that she has not submitted any explanation in response to the letter, nor had.
No, let me just read out the order so that it will be easier for you also. Mr. Manasyan, Learned Counsel appearing for the petitioner, submits, referring to the order passed by the sub-collector under Annexure 4, that the statement of the supervisor Damayanti Jena was never recorded but mentioned so in the said order. Damayanti Jena statement record heichi ki nahi dekho.
No, that record, the CDPO says that is not available because she has not submitted any explanation and all that.
Signature, what has happened? It is in my case that I have submitted my leave application and I went for the purpose of a test tube baby. I stayed in the hospital for about 7 months. When I returned, thereafter I tried to join, it was not accepted. And by the process matter, they have issued an advertisement that you join by the within a period of 7 days. Just after 7 days, because the time period was from August 2019, the exact time period. And thereafter, when I tried to join, it was not accepted. And when the advertisement was there, before that, they have already initiated the action and they have thrown me out. And now in the particular case, in the counter, they have said that one signature of they have said that signature appearing on the leave application is a forged one. That is their case. That's why I have made a mention that this has not been inquired and no corresponding explanation has been sought for from the supervisor.
Where has it been mentioned in Annexure 4? I have referred to in my order, but let us see. This is the impugn order, Annexure 4.
Annexure.
Order passed in pursuance of direction of the Hon'Ble High Court Lekhala.
As per the previous direction of this Hon'Ble Court, this was passed by the sub-collector.
No, sir, but here there is some mention about Damayanti Jena.
Yes, madam. Madam, see.
সেটা তো দেখা যাউনি যে আপনাଙ୍କୁ দেখা যাଉଛି ଟିକେ ପଢ ଦେ ମତେ ଦେଖା ଯାଉନି
I'm sorry for that.
ନାଇଁ ନାଇଁ ସରି କହିଲେ ବି ଦେଖା ଯାଉନି ମତେ ମୁଁ କହିଲି ସରି ପରି କହିଲେ ଦେଖା ଯିବ ବୋଲି କାହିଁକି ମତେ କିନ୍ତୁ ଦେଖା ଯାଉନି ମୁଁ ତାକୁ ଏତେ ବଡ କରିସାରିଲିଣି enlarged it to 100 and କେତେ 16%.
ଆମର ସ୍କୋପରେ ଯେତିକି ସେତିକି ଦେଖୁଛୁ
ସେତିକିରେ ଯାହା କରିଛି.
Second paragraph, CDPO has also stated that she has not submitted any.
ଜବକାଚ ମିଳେ ଆଜ୍ଞା ଜବକାଚ ଜାଣିଛି ସିଭିଲ କୋର୍ଟ ମାନଙ୍କରେ ଗୋଟେ ଜବକାଚ ଥାଏ ଆଉ ଗୋଟେ କ୍ରିମିନାଲ ପ୍ରାକ୍ଟିସ କରନ୍ତି ଆପଣ ଜାଣିବେ
କୋଉଠୁ ଆଣିବେ
ଜବକାଚ ଗୋଟେ ପକେଇକି ଦେଖିବାକୁ ପଡିବ. I have a ଜବକାଚ only to read these illegible documents, particularly in civil matters. Yes, it is absolutely necessary.
Old documents.
One, nahi, Mr. Das would know. He is very experienced in that. If you do one particular word, it can mean many things. So you have to use a magnifying glass. Magnify
See the part.
পড়ো।
CDPO has also stated that she had not submitted any application for to her. If it is submitted that she was in serious condition, she could have sent it during any time of her leave tenure. So the leave is treated as unauthorized. CDPO during her visit to the concerned AWC on 22nd of March 2018, 14/8/2018, 6/10/2018, she found that the Anganwadi worker Gayatri Meher was absent without submitting any leave application. As such, she is a habitual absentee. Without having permission leave Anganwadi center.
No, you come to the next page. Oh, the applicant has failed to prove her sincerity in discharging her duty. Lady Supervisor Damayanti Jana during her visit to concerned Anganwadi on Ete and Ete, Srimati Gayatri Meher. During her visit, she noticed following deficiency and reported to the CDPO Khayar. This is what I wanted. Where is her statement?
That is one aspect, and Madam has turned to page 27. In the appeal, where it has been taken, I have taken a ground that I have submitted my application, complete in all aspects before.
No, I'll ask you again, but I'll also ask you to, you have a date chart. You'll have to prepare a date chart.
Okay.
Anyway, but so this appeal, what happened?
Appeal matter has been dismissed, madam.
27,
Madam.
page 27.
The ground of paternity which I have advanced, it has been held by the appellate forum.
No, let us try to know.
Madam.
When did you apply for?
On 1/1/2000 and
First, when did you apply for leave? It was maternity leave.
madam. Yes, maternity leave, madam.
Okay, 1/1.
One I have submitted, madam.
What is second submission of medical
Yes, ma'am.
certificate from a
On
private
one-
clinic is not acceptable.
1/1/2019, madam.
1/1/2019.
Madam. Para 5.
Maternity leave.
4/1/2019, I admitted in the hospital. 4/1/2019.
Yes.
Unfortunately, the miscarriage happened, and I returned and joined on 24th. Tried to join on 24/7/2019, my lord.
24/7/2019. Yes.
Sorry, my lord. 12/12/7/2019, my lord. I'm sorry.
All right.
12/7, my lord.
Oh.
It was not accepted by the authority, and they have served me a show cause 24/7/2019.
24/7/19.
my lord.
Focus.
My lord.
Yes.
That I approve this honorable court in writ petition. That is 16407 of 2019. Wherein my lord has said WPC number 16407 of 2019.
Yes.
By order dated 13/9/2019, it has been disposed of, directing the authorities that have been sub-collected to give me a scope and to consider my repension and also personal hearing. And pursuant to which annex number 4, my lord, came or passed, my lord.
Annex 4 was passed.
My lord. Against that, I preferred an appeal. There is annex number 6, my lord, wherein the appellate court has also dismissed my appeal, although I have contended that because the maternity leave.
There is Annex 6.
Again.
So your period of absence is from 1/1/19, according to you.
My lord.
1/1/19 to 12/7/2019.
Court, my lord.
They have referred to some 2018.
No, 2018 they have said, because when all these things was there, now they have prepared some document that on 18 I was absent for some period, but that is not the subject matter of this dismissal, my lord. And they have also said that for particular period, my lord, I have not given in the process of visiting of my officers. I was not there. I have not cooperated. That is the allegation. But to that, all charges not there. Those charges.
That is Mr. Das.
Sir.
That is not the within the scope of the appeal.
No.
The appeal was specifically, let us see the show cause. Where is the show cause notice?
Sure.
Show cause notice 18/2018 কথা লেখা আছে। And that has been issued No, I'm looking at it.
ଏତଦ୍ୱାରା ଆପଣ ଜଣେ ଶିଶୁ ବିକାଶ ତଥ୍ୟ ଅନୁଯାୟୀ ଆପଣ ଉକ୍ତ କର୍ତ୍ତୃପକ୍ଷଙ୍କ ବିନା ଅନୁମତିରେ ନିଜ କାର୍ଯ୍ୟରେ ଦୀର୍ଘ ଦିନ ଅନୁପସ୍ଥିତ ରହି କେନ୍ଦ୍ର ପରିଚାଳନାର ଅବହେଳା ପ୍ରଦର୍ଶନ କରୁଥିବାରୁ ଶିଶୁ ବିକାଶ ପ୍ରକଳ୍ପ ଦେଇ ଖଡ଼ିଆଙ୍କ ପତ୍ର ସମୟ ଆପଣଙ୍କୁ କୈଫିୟତ ମଗା ଯାଇଥିଲା। So you the first show cause which was issued to you was 22/10/2018.
Madam.
ଆପଣ ଉକ୍ତ ପତ୍ର ଗୁଡ଼ିକର ସନ୍ତୋଷଜନକ ଉତ୍ତର ଦାଖଲ ନ କରିଥିବାରୁ ଏବଂ ଅଙ୍ଗନବାଡି କେନ୍ଦ୍ର ପରିଚାଳନା ସହ ଅବଗତ ହେଇନଥିବାରୁ ଆପଣଙ୍କୁ କର୍ମୀ ପଦରୁ ବହିଷ୍କାର କରିବା ପାଇଁ ଶିଶୁ ବିକାଶ। ୟାର ରିପ୍ଲାଏ ଆପଣ କଣ ଦେଲେ?
Madam, sit on that madam date 24/7/2019.
24/7/2019.
Madam. And this madam may see the advertisement was there, paper advertisement was there. That is that although I have not filed, but in the counter madam they have given that particular advertisement. It shows that paper advertisement. Annexure page 21 madam. That such and such ବାରମ୍ବ କଲ ଏହି ଖବରଟି ଖବର କାଗଜ ମଧ୍ୟରେ ତୁମମାନଙ୍କୁ ସୂଚିତ କରାଯାଉଛି ଆସନ୍ତା 7 ଦିନ ମଧ୍ୟରେ 6/8/2019 ମଧ୍ୟରେ ନିଜ ନିଜ କର୍ମକ୍ଷେତ୍ରରେ ଯୋଗଦାନ କରିବେ ନଚେତ ଆଇନ ଅନୁଯାୟୀ।
এটা କୋଉ ଜାଗାରେ ପଢୁଛନ୍ତି? ପେଜ 21
ଆଜ୍ଞା
କାଉଣ୍ଟର।
Counter.
ସେନ୍ କହିଲେ 6/8/2019 ଭିତରେ ଜଏନ କରିବା ପାଇଁ, ବଟ୍ 9/8/2019 ରେ ଦେ ପାସ୍ ଦି ଫାଇନାଲ ଅର୍ଡର ଅଫ ଟର୍ମିନେସନ ଅର disengagement.
So thereafter.
And one more thing also, if you might take note of from the counter. In the counter, they have said,
Hey, where was it inquired into? The show cause was issued, she gave a reply and that was rejected. How does it satisfy the standard of proof?
another thing, my lord, can I have bear me for a moment? Counter affidavit, page 25. Annex number D3, my lord.
Yes.
It was 14/5/2019. Madam, see the last para. Therefore, I would request you to give us a clarification for disengagement of Gayatri Meher Anganwadi worker, such and such, to take further a course of action at the end, my lord. So, from this particular letter, it says implies that on 14/5/2019, all effort has been taken to throw me out, my lord. Whereas the advertisement has been made in the last part of the year, July. 2.5 months thereafter only advertisement they come that you come, otherwise we are going to take action.
No, in this annexure 4,
Madam.
as we have seen, there is a reference to that statement recorded by or the visit by the Damayanti.
That exactly my lord has pointed out, directed to authorities, the state council to take note of.
So how do we know that all these things have been proved? So that we have to find out from the original.
All that was there has been submitted in the counter affidavit.
You have to go through it. Please go through it and so what is your case? What is the stand taken by you?
Unauthorized absence and non-response to the show cause.
Yes, so that has to be proved to the satisfaction of the court. That's all. No, people
I pray your lordship may send it back to the ADM for reconsideration.
Why?
If at all it is required.
No. But I have asked a specific question on the previous occasion whether this Damayanti Jana.
Gayatri Meher.
No, Gayatri Meher is the petitioner.
Aye.
My order is that whether that Damayanti supervisor, Damayanti Jana, was her statement recorded, because it is on the basis of her statement that this action has been taken.
Well.
So where is her statement? That is what I would like to know. It must be available in the file.
So let
It
me,
could be available, if at all, because Annexure 4 refers to it.
now the CDPO has referred only to her applications if were made, and said that it was not made, nor she gave any explanation in response to the letter.
No, if necessary, you'll have to, the CDPO will have to, or the sub-collector will have to file an affidavit. Actually, the CDPO.
CDPO.
লিখিলে lady supervisor Damayanti Jana during her visit to concerned Bhulia Sikua Anganwadi Center on 21/10/7/24/7/5/9/25 पूरा 5 दिन 1 2 3 4 5 दिन Srimati Gayatri Meher was found absent without any leave application. Where is that statement?
Medical period tag, medical leave.
And she has also found out some more discrepancies. Or so how do we know? Where is that statement? That statement has been relied upon.
Let me get that record.
Yes. Learned her further, no, Learned State Council is ready with the concerned file. But he is unable to trace out any statement given by the lady supervisor Damayanti Jena referred to by the sub-collector in his order under Annexure 4. List this matter. When do you want? You can take it up. List this matter. I heard further arguments in part. List this matter on 24th July. Learned State Council shall assist the court appropriately in this regard. Yes.
I also got the judgment on maternity.
Yeah, maternity. Upon could leave the application. That
is the in the appeal period, in the appeal at page 24.
Another thing, I have found that the ADM has also said that you have produced documents of a private clinic, which are not acceptable by the government.
And government hospital, if this test tube baby facilities are not there, that has constrained me to.
Yes.
I don't know, 8. Number 8, my lord, your lordship had heard this matter in the last occasion. The State Council was to answer, my lord, just to, my lord, recapitulate, my lord, your lordship may kindly have a glance at my additional affidavit. But my lord, this Andhra University matriculation was equivalent to the Board of Secondary Education matriculation, my lord, examination. Till a particular date, my lord, that is 30/11/1989. These petitioners, they had appeared earlier, but they could not clear all the subjects. So subsequently, my lord, appeared before this cut-off date for the first time. And they subsequently, my lord, appeared in the other papers and they cleared, my lord. In the similar situation, if your lordship will kindly have a glance at my additional affidavit, my lord, one similarly situated candidate. Lordship got it, man.
Yes.
Lord, page 9 of that affidavit.
Yes.
Annexure 15.
In
Hemasundar Rao, my lord, he also appeared for the first time before this cut-off date and subsequently he cleared. A clarification was sought for by the my lord, project office to clarify whether he is eligible to be continue or not, my lord. And subsequently, under Annexure 16, my lord, of course, that is an internal communication. I do not know what has happened, my lord, but subsequently, under Annexure 16, my lord, his services were regularized. So, your lordship, on the last occasion, your lordship had asked the State Council to argue on the.
Yes. So, may be permitted to place the paper. My lord, on 25th March 2003, first advertisement was issued for this Swachhasevi Shiksha Sahayaks. My lord, I have prepared a date chart, my lord, I will provide it, my lord. Just I am placing it there. My lord, on 25/3/2003, my lord, the first advertisement. This petitioner, also, my lord, he had appeared. But in the first page of selection, my lord, he could not succeed. My lord, I am telling about the petitioner. All the 3 petitioners were identical placement. Then on 26/9/2003, government issued a letter that without going for any fresh selection, the waiting list candidates, they may be permitted to get a job. A list is to be prepared utilizing that particular waiting list, and the engagement orders are to be issued. On the basis of this 26/9/2003, my lord, on 18/12/2003, these petitions they got selected. And they got engaged, my lord, on 20th December 2003. Then cases were filed, that is leading case, Hushikesh Mindani case. In WPC number 11748 of 2003. It was disposed upon 29/4/2004. Wherein this 26/9/2003, which was the basis for giving the appointment to engagement to all the waitlisted candidates, my lord, that was quashed. with the direction to issue fresh advertisement. Then, my lord, in September 2004, the advertisement was issued, and on 9/1/2005, previous notice was there, and my lord, that notice was modified, indicating that on 20th January 2005, the final merit list, final select list will be published. Whoever has any objection, they may submit the objections, and the schedule was also provided with respect to the different steps to be taken, just like certificate verification and other things, madam. The name of the petitioner didn't appear in that particular list. A select list was prepared on 20th January 2005, but that this particular petitioner's name, that was not included. Similarly, in WPC number 1102 of 2005, 3 individual applications were filed by the 3 applicants, 3 petitioners, before this honorable court, and there was an interim order not to take any final decision in that regard, my lord, with respect to retrenchment of this matter. Then they continued, my lord, on the strength of the interim order passed by the honorable court. Then thereafter, my lord, on 30th January 2009, the petitioner submitted a memo for withdrawal of this, and that was dismissed for withdrawal, dismissed as withdrawal. Then, after dismissal of the case, and when the interim in force, my lord, the petitioner was issued with a so-called notice. Why his services shall not be disengaged, my lord. Then he submitted his so-cause. Then his so-cause were not found to be satisfactory, and accordingly, he was dismissed from service. So, in the entire case, my lord, the first point is to be seen, my lord, that the petitioner's name was not included in the second select list, that is of 20th January 2005, challenging which, my lord, he had approached before this honorable court. And that writ petition was initially entered and interim order was granted, but later on its own motion, my lord, that was withdrawn and dismissed. So, with respect to inclusion of his name in that particular select list, a writ petition was there and it has been dismissed, my lord, as on date. Now, in view of Husikas Mindani's case, my lord, unless and until the petitioner finds his name, my lord, in that new select list, he cannot claim to continue in respect in terms of the previous select list, my lord. He was continuing on the strength of the previous list, and that was already held to be illegal by the honorable court, my lord, in Husikas Mindani's case, as for the decision of 29/4/2004. Now, coming to the point, my lord, that why his case is not to be considered and why he is not to be included in that select list, my lord. To that extent, my lord, we have stated that the dates are relevant, my lord, that he appeared in the examination during October 1987.
That matriculation.
Andhra University, my lord. And he successfully completed the same, my lord, on 7/6/1989. And the equivalency status was up to 20th September 1988. So, my lord, on the basis of this particular government notification.
No, but a different view appears to have been taken in case of that Hemasundar.
Yes, I am coming to that, my lord.
Okay,
Now, this is with respect to what I submitted, my lord. This is with respect to the advertisement of 2003. Hemasundar's case, my lord, it is up with respect to the subsequent advertisement of 2012. Wherein the minimum qualification, here the minimum qualification is HSC. There the minimum qualification is +2. With respect to +2, my lord, the certificate is still in force. The document, whether it has equivalency or not, the institute, the government institute where he studied that +2, my lord, Hemasundar, that was accepted. And the minimum qualification here, my lord, it was +2. The authorities had not to take into consideration anything with respect to the HSC, my lord. But here the basis of selecting a candidate is HSC in respect of the previous advertisement. And the HSC certificate, the petitioners are relying upon, my lord, that certificate is not a certificate which can be taken into consideration because of not having the equivalent status. So that is what, my lord, with an additional affidavit, we have indicated how Hemsundar Rao's case, my lord, is different from this particular case of the petitioner. Now, adjourned date, my lord, the petitioners are not disputing the fact with respect to their date of acquiring the qualification of Andhra University. They have never objected, they have never challenged the decision of the authorities letter, that is 25/11/1991, making it valid up to 29/998. So if these two documents are in force, my lord, putting the equivalency status only up to 20th September 1988, in that case, my lord, the petitioner having no minimum qualification. The fact that here is another point, that the issue with respect to inclusion of his name has already been dismissed. And my lord, there is a certificate, my lord, in the first page.
The writ application.
Yes, my lord.
He has given the,
There are two numbers, my lord. One is 112 of 2005 withdrawn. The order copy is very much available, my lord, in the writ petition. But with respect to 6641 of 2022, withdrawn on 11/3, I found it to be, my lord, from the website, my lord, it is 17/3, but the order is not there. ଅଛି ଆପଣ ପାଖରେ 17/3/11/3 order ଟା ଯୋଉଟା
WPC.
ସେଟା actually 17/3 ଦେଖଉଛି କିନ୍ତୁ
WPC
order ଟା High Court website
6634
ସେ
of 2022.
a connection error or something like that. ସେ ଦଉନି ସେଟା
It was permitted to be withdrawn. The printout work. Printout work.
but whether with liberty or not, my lord, I don't know.
Leave it.
So my lord, the second case,
Non-counsel for the petition and details fairly submitted by petitioner that in view of the defects pointed out by the registry, he may be permitted to withdraw the petition with liberty to file it afresh. Petitioner kiye dekhi?
ତିନି ଜଣ ତିନିଟା
Then
case
issue
ଅଛନ୍ତି. I have verified the rate. I could not see that order. But my
It was
lord,
permitted to be withdrawn with liberty to file a fresh application.
so my lord, there are two cases. One is 1102 of 2005, which
1103.
31.
1103 of 2005.
Sorry, my lord, I am referring to last time it was N. Pitambar Rao.
Acha.
It's okay, my lord. Tinta case over. In that case, there is no liberty which has been granted. With respect to inclusion of the name of the petitioner, my lord, in that list of 2005, after Hushikesh Mindani's case, my lord, that particular decision, my lord, in that writ petition, lordship may come to page number.
You mean to say that he is stopped to raise that issue again?
Yes, that because
So question of
that is
stop.
also a point, my lord. It is how it is different from Hemsundar, my lord. I'm just pushing that one.
No, that I got it. But fact remains that he was included in the first select list.
Yes,
That was held to be illegal by this court.
yes,
In that Hushikesh Mindani's case.
Hushikesh
So
Mindani.
that has to be examined now. That has to be examined.
In that case, my lord, Hushikesh Mindani case, my lord, that was, my lord, in respect of the districts where, my lord, there was no proper advertisement.
But you were affected.
No, Gajapati was not there, my lord, that was not affected because, my lord, by this honorable court, subsequent decision, my lord, by Honorable Justice A.S. Naidu, my lord, the honorable court said that, my lord, it is in respect of the particular.
Let us bring Hushikesh
But this
Mindani.
is,
Yes,
this is not binding for so far as all the.
Mr.
districts
Mishra,
are
let us see Hushikesh
concerned. Yes,
Mindani.
my lord, that can be examined
We can take it up tomorrow.
tomorrow.
Hogani? Tale next week koriya? 18 tarikh. Heard further arguments in part, list this matter on kete hoyche na? On 18 July. Parties are requested, the learned counsel for the parties are requested to address the court as to the implications of the judgment passed in by this court in Hushikesh Mindani's case.
my lord,
My lord,
I'm
the-
submitting it.
The part which they are raising now, my lord, that estoppel, my lord. My lord, I have explained in my application, my lord, that there was a promise, but
We'll see that, we'll see
Yes.
that.
my lord, they said that you will be regularized, you withdraw the cases, my lord. So accordingly, on good faith, we withdrew the cases. And subsequently, there was disengagement order, which I am challenging. That was a different issue altogether, and this is a.
All right. Item number 9.
Yeah. Since relating to appointment of an Anganwadi worker, my lord, and advertisement was made in the year 2006. And thereafter, the selection, I stood second in the list. The first one was Chili Veg, opposite
Mr.
partner of 4.
Saudangi was, were you appearing in this case earlier? Your
Yes.
name finds place in our order.
Yes, I am appearing, your lordship.
You were appearing, or now you are also appearing.
Yes, I have instruction to appear. Okay. If your lordship permits, there is no allegation against me. I have been added at a later stage.
No, you are appearing for whom?
7.
The order, right?
Newly added.
It is Renuka Swami though. Renuka Swami is the petitioner.
Petitioner.
Lord,
Opposite partner
what
Milan Rao
appointment was
No,
challenged.
Renuka Swami is the petitioner.
Renuka is the petitioner.
Sir, Renuka Swami is the petitioner.
Renuka Swami petitioner.
Yes, my lord.
Petitioner.
भूल लिखा है ये चीज.
I appear for
नहीं.
Milan Rao.
Order dated 24/4/2024 be corrected to the extent of mentioning the name of Sri S.K. Saudangi, Learned Senior Counsel. As representing opposite party number
7.
opposite party number 7. The name of Sri S.K. Naik be reflected, who appears for the petitioner at the appropriate place. Yes, कौन है?
Sir, ଏଥିରେ ଗୋଟେ prayer ଅଛି. ମୁଁ ଗୋଟେ affidavit ready କରିଛି file କରିପାରିନି.
2006 matter.
ଆଜ୍ଞା. ନାଇଁ ମୁଁ sir appear କଲି ଏବେ.
No, maybe, but the matter is 2006.
22.
So,
Was disposed of. It was disposed of previously. And
Yes.
thereafter, as per the order of the appellate court of Malad, thereafter
it has been remanded.
remanded.
Yes, what do you say, Mr. Naik? You want to file some affidavit?
Lord, opposite party number 4's appointment was challenged. And while the writ petition was pending, she resigned from her post
He wants to file an affidavit.
in 2017. Thereafter, new advertisement was made. That new advertisement, when made, the single judge disposed of the writ application, saying, since new advertisement has come, writ application becomes infructuous. That order was challenged in writ appeal. And writ appeal, that order was set aside with an observation that the cause is subsisting, nothing is, so it could not have been disposed of. So the matter was remanded back. So now after remanded back, opposite party number 7 has been appointed in view of the new advertisement. So she has been added as a party. So my contention is, my lord, since opposite party number 4 stood first, I stood second. When she resigned, I am the next contestant, so I could have got the post. So there should not be any new advertisement. That is my contention.
No, he wants to file an affidavit. Let him file an affidavit.
With respect to that submission matter only, that in case of resignation or in case of non-joining even matter,
There has to be a fresh.
new advertisement is to be.
We'll see the rules. We'll see.
ଗୋଟେ inquiry report ଅଛି.
Does he have any right or not? We'll see that. Whether he acquires any vested right by merely being included in this select list or not. Sri S.K. Saudangi, Learned Senior Counsel, appearing for opposite party number
7.
7. No, you cannot say that. So who's appearing with you?
She is appearing it.
What is your name?
Swati
Yes?
Yadav.
Swati Yadav. Ms. Swati Yadav, who is assisting Sri S.K. Saudangi, Learned Senior Counsel for the opposite party number 7, submits that an additional affidavit. An affidavit is to be filed on behalf of opposite party number. Affidavit is to be filed on behalf of her client, for which she requests for a short adjournment. When will we take it up? 2006 matter, I will not give a long adjournment. All right, list this matter on 24th July. Affidavit, if any, be filed in the meantime. Item number 10.
Petitioner, the lecturer in English and the relief set for non-payment of the reader scale on the career advancement scheme, my lord. Although the juniors already availed due to laches and dereliction of the duty by the department for non-submission of my CCR in time by OP number 3. And other day, Lordship already set instruction from my senior about the annexer 8, my representation, what they have acted upon.
Yes, what happened to his representation dated 12/7/2010? The director.
Till date, my lord, we have not received any instruction to that effect. But what we have received a copy of the PWC from the principal. Wherein the principal also says, my lord, the same thing. That because for the non-availability of the CCR for a relevant period, there is
It is a 5 years CCR.
5 years of CCR.
So 1 year.
But 1 year and few months CCR is wanting in this case, madam.
Yes.
That CCR was not there. So
Yeah, he should have
applying the
corrected,
provision of the
he should
relaxation.
have corrected it from the previous institution or relaxed it. There's a provision for relaxation, I think.
That's
such cases.
also the copy is also available, my lord.
So how can,
In terms of the
on that ground alone, how can you deny him that? I just want to know what happened to his representation pending before the director, if at all.
that decision, that currently, my lord,
Otherwise,
information.
if it has been rejected in the meantime,
That is directly.
then I cannot pass any order otherwise. So get that information that it is pending, so I can.
This matter will be taken up on 18th, my lord, we will take
Yes.
on 18th.
Pardon, my lord.
Leonard State Council.
My pardon. There are pendings of the writ. I have a copy that already director intimated to the OP number 3 to submit the CCR in every frequency. But day before yesterday.
I'll get the instruction from both director as well as from the principal, my lord.
Principal notice sufficient since long, and Honorable Judge, Chief Justice had queried whether sufficient in a post office that is
Sir,
inquired about.
Due to non-submission of CCR for the period from 1998 to 39/2000.
Ma'am,
Used to furnish the proposal afresh along with all ancillary documents. See, the principal's affidavit becomes relevant now.
yes, ma'am.
ma'am.
And since we have already received a far-fetched comment from them, my lord, we'll ensure to file the affidavit. Because the far-fetched comment
Now-
also
now-
says valid in favor of him.
It's all right. So the CCR has to be given for the period from 98 to what's the period nahi keval?
Yes, एक good.
1.5 period, 2 years period ta nahi.
Ma'am.
So they'll obtain it from
Yes.
the previous institution if
Yes.
he was working there, or they have to finalize it and submit the proposal. Those who are pending which are
That
unnecessary.
is for the period from 1998 to 30th September 2000.
Yes,
Yes.
that is what the director also
Yes.
says. Have you taken a copy of it?
Yes, ma'am. Yes,
So
provided.
you prepare your counter accordingly, we'll dispose of.
Yes, will do.
Leonard State Council submits that he has received the parallel comments from opposite
principal.
party number 3 and requests for a short adjournment in order to prepare the counter. Place this matter on next week, huh?
Yes, ma'am.
On 18th, huh?
18th.
On 18th July, counter will be filed in the meantime positively.
Yes.
Item number 11.
I may plead the lordship.
Yes.
The petitioner was initially appointed as a lecturer in Ispat College, Hon'Ble, with an aided education institution in the year 94, pursuant to the advertisement as at Annexure 1.
He is working as lecturer in?
Lecturer in physics. Annexure 1, or 3, kindly indulge your lordship's attention towards Annexure 1. Page 14.
This is advertisement.
Advertisement. Nothing, nowhere it is stated, why I am trying to converse your lordship is, nowhere it is stated is a part-time or full-time. Therefore, I am trying to
Yes.
wanted lecturer the subject chemistry, physics, botany, zoology, economics, Oriya, commerce, history, Hindi, political science, and popular science. The candidate expressed possessing 51 marks, PG, only drawn in favor of principal such and such, and
Yes.
that will be such and such.
Just
They may not.
1 minute intervention. Here I appear for opinion number 3, the principal. He has sent in spite of my request, repeated request, he sent all the powers comment, somehow he has not come to file the counter affidavit.
You want to file the counter?
No, he is not coming. Your lordship, if your lordship wants his assistance, your lordship ask him to appear in person because I must have
It's a
talked to him.
humiliation to this.
Very nice way of putting it.
Very nice way of putting it like that.
Huh?
Apart sir, ବଢିଆ ଭାବରେ କହୁଛନ୍ତି ସେ କଥା କହୁଛନ୍ତି sir. The manner you are speaking is
But the appreciation is not coming from proper corner.
It will come. It will come.
all right.
No, so if you want to file the counter, let it.
No, I can't file because
I'll file that order.
the nature in which I have requested for him, both with the management and the principal,
All right.
if they are not coming, what can I do?
Hey, you see, this court cannot force anybody to file a counter.
No, cannot.
I cannot.
Cannot.
If it doesn't,
That is what I say. If your lordship wants assistance, then your lordship.
no, I'll record your submission. Call him.
No.
Why should I?
Not this one.
He will let him know. We will ignore his
Not
parliament.
come.
Or should we continue then?
Please, but if you like to permit, I can place.
No,
With the available record, I will submit whatever is possible.
All right, then.
That's it, see it now. Thereafter, after completion, I was selected. I was also appointed.
You were selected.
I was selected
Yes.
in the year 94 and I was appointed. But it was treated as a part-time lecturer. With that attitude, I was allowed to continue till 96. Thereafter, they terminated my service and fresh advertisement was issued. I approached this honorable court. This honorable court passed an interim order that one post of physics cannot be filled up in first writ application and directed the director, the application pending before him should be disposed of. The termination order against which I have made a representation to the director, that should be disposed of. That was the initial direction passed by the first writ application. Then it went to.
But that order which, Mr. Mishra, you are referring to a particular interim order which says that one post should be kept vacant.
While disposing the matter, that was directed initial say that you also get from page 20. That then direction was given to dispose by a case. Then you also kindly turn to page director decision, my lord. Page 23.
Yes.
Third paragraph, my lord.
Yes.
The scrutiny of later dated such and such submitted by the principal is Rahulkar and verification of records of the college and the detailed report submitted by the principal in OGC number such and filed by the Vijay Kumar Pradhan. It is transparent that the petitioner Rameshwar Prasad Mishra has been denied of natural justice, although he stands on a better footing from all respects, and also when the honorable court had directed in miscase number such as to keep one post vacant till disposal of the writ of petition, there was no bar on the part of the principal to appoint Sri Mishra as lecturer in physics. Therefore, without prejudice to the claim or claims of others, the principal cum secretary, Rahulkala, opposite partner of his director to reinstate Rameshwar Mishra as a lecturer in physics within 1 month from the date issuance of this order. Then it was not acted upon. Again, I approached this honorable court for compliance. My lord, the annexure 5 and 6 as my communication with the director for implementation of that. Again, my lord, subsequently turned to page 30.
Another writ application.
Another writ application filed by me. Initially, of seeking that there was the direction of the director is not implemented. Then, my lord, subsequently turned to paragraph page 36.
Yes.
In the concluding paragraph 11, my lord.
Yes.
In the concluding portion of the order, the director observed that without prejudice the claim of others, Rameshwar Prasad Mishra should be reinstated as election physics. Thus, no prejudice whatsoever would be caused to the premises Mishra or any other person. In view of the aforesaid discussion, WPC is disposed that Rameshwar Mishra has filed WPC number to implement the order dated such as in view of the WPC number, this court finds that
That is disposed of accordingly.
there is no impediment in the order dated passed by the director. This court therefore dispose represent directing the authority to implement the order passed by the director as expedient as possible. Then melody was not also implemented. Then they, after filing contempt everything, they filed a review application. Let's again look at page 3041. And their sole plea was at 42, page 42. Detail contest. Paragraph 3, Maro. In the review petition, the petitioner has not taken any ground for seeking review. except that the order sought to be reviewed is unexecutable and cannot be implemented due to want of post of lecture in Department of Physics in the petitioner's college. On perusal of the amendments made in original writ application filed by the petitioner, present petitioner, such as it is seen that no such ground regarding non-ability of post of lecture in the Department of Physics has been taken. Moreover, no plea to that effect had been raised at the time of hearing of the said petition. Therefore, no finding that regard has been recorded in the order. The H.S. Mishra counsel appearing for the review petitioner was not the counsel appearing for the petitioner in WP Sachana. Therefore, he is not in a position to say as to what was argued before the court and whether any such pleas regarding non-ability of post had been taken at the time of hearing of the order. Then you will secondly, the last part of the order. Paragraph 70. In the present case, the petitioner has not specified as to what is the glaring omission or error upon the face of record, which requires a consideration by your review. The only plea taken by the petitioner in the review petition is that the order sought to be reviewed is unexecutable and cannot be implemented due to want of post in the Department of Physics. The plea having not been taken either in the amendment made in the original date of petition or at the time of hearing of the same, it cannot be permitted to be raised now on the as a ground for review of the original order. Then, my lord, immediately, this is the order dated 11 January, my lord. Then your lord, second term, page annexure 10, page 49.
Yes.
I was given again appointment, a conditional appointment, my lord. 11/3/11. So I immediately give a reply, it is not in consonance with the order of the High Court. Page annexure, page 50. Then, my lord, after I joined on 11/4. And from 21/4/2000, another 10 days after, I was again terminated annexure 12. Everything has been examined, detailed discussion, director, division bench, again review allowed. Only 10 days I was again terminated. Bent upon, therefore the principal is not coming.
No. That is not the reason.
That is all. That is all.
That's all.
I have filed an IA for intervention. Only
Who are you?
only the concluding paragraph which my learned senior referred to lordship may kindly
Concluding paragraph of the review.
of the division bench judgment.
Division bench का review ना आ रहा था.
No prejudice will cause to you. One is trying to say is no prejudice will cause to you.
It clarify I have nothing to say because the lordship may kindly see my IA number.
No, that's all right. That's all right. I will consider. I'll pass order at the time of final disposal. I'd like to hear Mr. Mishra because you are the main person.
No, that is the reason. Here, my lord, my land friend has not said the initial appointment, the annexure 1, he said, your lordship can receive.
Annexure 1 is the
Advertisement, wanted lecturer. So he could have given in pursuance to that, what is the appointment he is issued. But as he said that for that reason the principal is not coming. It might say that for conveniently he has not produced that initial appointment order. That will clinch the issue. So he was initially appointed right from the beginning in the contractual post for a limited. That is the entire thing. As my friend said, the previous writ petition, which was sought to be reviewed. If your lordship will get that the order, it will clear. Here, that is, even now today, let him show the initial appointment order. The appointment order in which he was there is to be restored, reinstated. So he was appointed in a contractual post time to time, and he was reinstated. After the entire sanction post is filled up, where from he will be appointed. And it was not, the sanction post was not advertised, nor he was appointed against the sanction post from the beginning, at no point of time. That is why the review was sought for. But since the review, the ground of review is something, law is something different, the court did not say, but I brought it to the notice that there is no post, and he was appointed under the contractual post, which was, long over. But since the court order is passed, he was again given another same type of order, what he was given. Let him show the, your lordship may direct the petitioner, first show the what is the nature of his initial appointment.
That is part-time. That is part-time.
Reinstated part-time, inshallah.
All right.
There is no post. Beginning he was appointed part-time as he submitted without producing the copy of the order. I advertisement hele, selection hele, appointment order to be daba kotha.
But that is a point, Mr. Mishra, you have to contact.
Daba kotha. So he has not. Convenient or not
No,
giving.
you may not give, whether he gives it or not, but he admits that it was a part-time.
Appointment was, though advertisement was
But why it is not given? Your lordship knows, yes, your lordship knows, this is a court of affidavit. Once somebody says that I was appointed and it relates to a document, he must file that document. Or if the document is not available, he must give an explanation, even though he has referred in the writ petition, why he is not able to file the document.
No, that
Because writ petition, averment is not sufficient.
No, but I would like to.
If the averment is made relating to any document, first of all, if it is obtainable by certified copy, of certified copy shall be filed. If it is obtainable certified copy. Suppose a document is referred which is not obtainable certified copy, but that document has to be filed. If the document is not filed and there is some secondary evidence, some other document is filed, that explanation has to be given by affidavit, why it could not be filed. So this is it is a suit boy, trial
No, I would like to ask Mr. Mishra one thing. The advertisement says that it was on purely temporary basis.
yes, everything, all appointments are temporary.
That's all right. That's all right. I take your point. But you were appointed admittedly as a part-time lecturer.
Successful,
Mr. Mishra, you never challenged it. You never challenged it.
I challenge the subsequent advertisement, which where I was, then they tried to substitute me. In that case, this court categorical directed, you keep one post. Even, considering for the sake of argument, the plea they are taking, there is no vacancy, there is no post, it cannot be accommodated. That has been rejected by the review court. You were raised in the review only, not in the pleading.
All right. Yes. What is the stand of the state?
The state has nothing to do here.
And Mr. Directorate, how are you connected?
This is a non-government aided college receiving block grant, your lordship. I was appointed in the year 1992. In the previous writ application, I was also intervened because he's claiming I was appointed on regular basis as a lecturer in physics. He was appointed part-time, whatever, that is a separate dispute altogether. But in the meantime, this honorable court directed in para 11, which my learned senior.
But that is without prejudice.
No.
So he's not eating into your post.
For that I only have.
And the court also protected his.
The fact remains that Mr. Mishra's client is not eating into your.
No.
So you have nothing to say.
Only to be carried
Whether you are made a party or not, it doesn't matter.
my lord.
But I consider it anyway. Hearing
In the meantime, his post has been approved. The 5th post of physics.
your post.
My lord.
Actually, that has got no meaning.
That other judgment which was sought to be reviewed, that original judgment may be called for.
Oh, it is there?
Yes.
It
That
is
may
there?
be seen.
No, it is there.
That may be seen. Review can't be referred. The writ petition.
Yes. I'm closing it. Mr. Mishra, I'm closing it.
Full matter.
Hearing concluded, judgment reserved. I'll just pass an order. Parties may file their note of submissions and memo citations, if any, within a week, if at all.
I don't think it is because all judgments are available here. I rely on the judgments passed by this court and.
That is not a court. It gives court 7 days time to prepare for the judgment. I don't like to keep my judgments pending. So.
I'll also file a small one because.
Here the judgment itself is there without prejudice to the claim of Devasis Das and others. And probably he is finding. Missing power dokan nahi. If I say something wrong, you contradict only. It is the pala no hai, jahan mu koi tama sara seta hai repeat karo.
Sir, I do not 12.
Kindly take note next.
2012 matter.
Mr. Swai ji, my lord.
All right. Place this matter next week as prayed for by Mr. Swai. Yes.
My lord, I am for the petitioner.
In item 13.
Yes, ma'am.
Yes.
My lord, I just received the counter today. Itself, I need some time to file the rejoinder.
Learned counsel for the petitioner submits that she has received the counter affidavit filed by the university. University. Today.
OP number 3.
You answer, Mr. Learned counsel appearing for which university?
Utkala University.
Utkala University files counter in the court.
Utkala University of Culture.
After serving copy on the counsel for the petitioner, who wants some time to go through it. Place this matter on 7th August. Rejoinder, if any, be filed in the meantime.
My lord, interim order to be continued.
No, interim order jete achi, it will continue.
My
What is the
lord,
interim order?
My lord, I've instructed.
interim.
What interim order was passed?
Petition.
You are making a prayer to continue the interim order. I want to know what interim order was passed. You don't have the file. Why have you come to the court without the brief? Why are you making a submission to the court without holding the brief? You are a young counsel. Why are you making this mistake? And you are making a submission to the court. You don't know what the interim order was passed. Why should it be continued? Why should it not be vacated?
I'm sorry, my lord.
Saying sorry will not do. Next time onwards, if you don't have a file, I'll dismiss your case. Yes.
My lord, earlier your lordship directed to appear on behalf of the chancellor, but till date Bhakalatnama has not yet been come to me.
You will appear. No,
No,
I think Mr. Udgata usually appears.
Yes, your lordship directed earlier, and the university has issued a letter to me. That letter is submitted by me.
Well, Mr. If he doesn't, no, you
Yes.
say that you have received instructions to appear for the.
Yes.
If you don't receive Vakalatnama, what can the
Yes,
court?
ma'am. Till date,
We received the counter filed by the state as well as the opposite party number 5.
One received in the year 2019.
2019, yes, sir.
Till date by reason.
Counter टा मैं receive करছি.
No, mobile, I have the receipt that you have received on 4/1/2019. This is the receipt.
One look again to. In the meantime, your lordship,
Last chance.
opposite party number 5. Alien affidavit before the executive magistrate. Stating that the not contested the matter. And if the petitioner is continuing the Anganwadi worker, she has no.
What is the value of that affidavit?
Yes.
Yes, Mr. Behra. What is the value of that affidavit? Anyway, please this matter next week as prayed for. It is made clear that no further adjournment shall be granted.
Yes, sir. Interim order.
Interim order to continue.
Item number 16.
In this parawise comment has been received, but counter affidavit could not be filed. If the lordship grants some more time, that will be filed.
We have thus learned AGA. He submits that he has received the parawise comments and requests some time to file the counter affidavit. Is this matter on 31st July, counter affidavit, if any, be filed in the meantime, after serving copy on the other side.
Item number 17.
31st July.
As a last sentence, बहुत दिन है grant time.
It is made clear that no further time shall be granted.
Item 17.
17 may please, lordship. So I'm submitting the date chart, lordship. Lordship, here is the case.
You are appearing, Mr. Manti?
Yes. Opposite.
Yes, brother, what is the prayer? Let me see.
Lordship, I have
Passing
challenged
annexure 1. What is annexure 1?
Annexure 1 is the order of
8-1.
appellate authority.
Yes. Place your date chart.
So before placing the date chart, I'm in just saying what is my case is the petitioner is a resident within the service area that is not disputed. Petitioner has secured more marks than the private opposite party number 5 who has been selected as the Anganwadi worker is not disputed. But in the in-laws house and the parental house of the petitioner is the same resident area is not disputed. What I have done, my lord, I applied, submitted a resident certificate. In the resident certificate, the Tahsildar, instead of my husband, he wrote as the name of my father. Because my father's house and in-laws house in the same resident area. CDPO directed me this, no, the certificate is required in name of husband. On the date of verification, the CDPO himself, the lady supervisor, and the Anganwadi worker, they themselves conducted physical inquiry. They found that they also found that I am within the service area. My case has been rejected because I filed the corrected certificate in name of my husband after the cut-off date. That is the case of rejection. My submission is, lordship, the first certificate
is not invalid in the eye of law as per the requirement of the advertisement. Let's you kindly see the first, the advertisement was issued annexure to page 15. This is the page 16 lordship, page serial number 12. आवेदन करियार शेष तारीख होची 9/5 आ ता पर दिन होची डेट ऑफ वेरिफिकेशन लॉर्डशिप एंड दी दरखास्त फॉर्म सहित निम्नलिखित प्रमाण दाखल करिया हबो क्लॉज नंबर 5 रे लिखा हिची स्थायी बासिंदार प्रमाण पत्र संपुक्त तहसील ठार ग्रहण करथिबा आवश्यक एवं यह आदेश पाइबा 6 मास पर्यंत बलवत्तर रहइबो द सेंटर इज लॉर्डशिप विल फाइंड पेज 21 एट सीरियल नंबर 17 विश्वनाथपुर मिनी अंगनवाड़ी केंद्र संपूर्ण विश्वनाथपुर पड़ा ग्राम को नहीं सीमा निर्धारण करा जायछि then lordship will say next page 22 my application form. Now application form, just below my application form, the signature by the lady supervisor, CDPO and the Anganwadi worker of the mother Anganwadi center. They found that I am within the resident area. Thereafter lordship will kindly see page 23. I have submitted all these documents, including the residence certificate. The residence certificate, lordship, kindly see what I have incorporated in the application form. That is, lordship will find on page 26.
26.
Page 26.
Yes.
This is Bhavanarani Mohanta, daughter of Sri Tirandra Mohanta, my father's name. Then, lordship, I have also submitted an affidavit what is required as per the advertisement, page 28, that I have stated that I was also belong to the resident area. Page 28, lordship.
Yes.
This is the affidavit submitted along with my application form. Now, lordship, kindly see page 30, annexure 5. This is the comparative statement of selection of Anganwadi worker. Page 30. Serial number 2, I have secured 49.5, lordship, total marks. The serial number 3, that is the present opposite partner 5, he has secured less than me, 36.66%. My rejection in the side column is stated that resident certificate not submitted at the time of verification. Now, lordship, kindly see, the earlier application which I have incorporated in my application was not accepted. That is why I was directed to produce the second application. Second application, lordship, I have annexed resident certificate, annexure 7, page 32. This is also the address is same, but this is the name of my husband. What they demanded. This is issued on 14/5/2017. That is after the cut-off date. But immediately on the same date I produced. Now the appellate authorities finding, lordship, will kindly see. They say that the certificate, the subsequent certificate on 14/5/2017, I have submitted beyond the cut-off date. That is not to be accepted. So my submission is, lordship, the Anganwadi guideline never requires a resident certificate in the name of father or the name of husband. But what is required is he must be resident of the service area. That is not disputed. My in-laws house, my parental house, that is also within the same Anganwadi area. Lordship will kindly see page 11.
No, I've seen it.
What is, I have placed entire cases.
Yes.
Your Lordship wanted to see to the appeal records that we have sought for, but we have not got it.
Why was the appeal record?
That Your Lordship the other day,
You felt it necessary to put that was in 2/2/2023.
Last session, your Lordship directed, or last time also your Lordship directed.
Why did I direct?
to look to the,
Entire record, your lordship found.
Kindly.
The previous session, your Lordship
Do
directed.
2023.
I guess.
Do 2023 order pass when this assignment was with me earlier. I don't remember.
on
But,
26th of June also.
But
you-
anyway, is it necessary? In view of whatever submission he has made, that is to be
Wanted
considered.
to-
I'll hear Mr. Mahanti and I think Okay. When State Council submits that the relevant file has not been obtained. So, since last chance was granted to the State Council on the previous date, Kumar, no further time is granted. The writ application is taken up for hearing. Yes, Mr. Math. You have heard him, you have to give a reply, that's all.
Pardon me.
You have heard him, you have to give a reply.
I have filed my counter affidavit as well as the original counter affidavit.
What is your stand? Just tell me.
Pardon me.
What is your stand?
And I am submitting. As per the advertisement annexure 2, last date for submission of application is 9/5/2017. Petitioner and opposite party number 5 applied for the post of Anganwadi worker in Vishwanathpur Mini Anganwadi Center. Petitioner enclosed all the documents. She submitted a residential certificate in the address of her father instead of the address of her husband. By the cut-off date 9/5/2017. Since petitioner is married lady, residential certificate is to be appended indicating the residence of her husband, not in the name of her, after marriage, not in the name of her father. If she was unmarried by that time, then she can apply in the name of her father instead of her husband.
Is there any such provision in the Odisha miscellaneous certificate rules?
If it is necessary, because after marriage, she became the residence of her husband. And the residence certificate.
Mr. Mata, how do you know? Even after marriage, she may have come back and maybe reside in the
If divorce is there,
no, divorce no, you know, Papa Horasi Rogar Kuman.
কিন্তু ম্যারেজ পরে সে গণা হব যে তার রেসিডেন্স
মানে তার অরিজিনাল
আইডেন্টিফিকেশন হব যে
no, তার অরিজিনাল আইডেন্টিটি as the daughter of such and such is obliterated forever.
Is after marriage. My submission is after marriage.
Okay.
I'll file my written note along with the citation.
All right. Hearing concluded.
I'll put the
written note କହିଲେଣି ମୁଁ କହିଲି ସରିଲା
I'll put the କହିବି. The selection committee has passed order. Yesterday I filed the original counter affidavit. It is not in file.
You have received copy. I ଦେଖନ୍ତୁ କପିଟା ଦେଇନାହାନ୍ତି ତାଙ୍କୁ. Oh, Learned Sri Mahanti, Learned Counsel appearing for opposite party number 5 files additional counter affidavit in court. এইটা অরিজিনাল
না অরিজিনালটা কালি ফাইল করে দিয়েছি।
A copy of which is served on the other side in court. Please this matter next week. Heard in part kar dem. Heard in part.
কালি ফাইল করে দিয়েছি।
Will come next week. Yes.
Item number 18.
18.
না কালি ফাইল করে দিয়েছি কপি দেখি।
Yes.
Sir, last day to ଆପଣ ତ affidavit ମାଗି କହିଥିଲେ ଆଣିବା ପାଇଁ ସରକାର ଓକିଲଙ୍କୁ ସେ କଣ କହିବେ?
Yes, Mr. Das. I made it clear that I will not grant any further time.
Yes.
Since he is appearing in person. There were 16 vacancies at the relevant time.
Yes.
Out of which one was reserved for physically handicapped.
Yes.
He was the second physically handicapped appointment person. The first candidate never joined. So he ought to have been given appointment. This is the only query.
Yes.
What is your answer? I have said that you requested for a week time. I said that the petitioner is conducting his case in person. This court is ordinarily not inclined to grant further time. For the ends of justice, matter is adjourned to law. Yes, what is your reply?
In the last letter, they have prayed for 2 weeks' time to enable the state opposite party to file the required counter.
No, this is unfortunate. Who is to give this reply? Let him appear. Who is to give the reply? And he will appear by tomorrow. BO.
BO.
And this person is appearing in person. The petitioner is appearing in person. How the orders of this court, scant regard is being paid to the order of this court. I'm sorry to make this submission.
Should not have been.
No. Then State Council requests for time to comply with the previous order. Similar prayer being made on the last occasion. This court had specifically directed the State Council to apprise the court as regards the query posed on
The last.
25/6/2024. It was observed that the petitioner has been appearing in person. And therefore, this court was reluctant to grant time. It is unfortunate that repeated orders of this court are not being complied with. Let the Director of Elementary Education appear in person before this court at 10:30 a.m. tomorrow. And
May not be possible.
no. You can't say anything, Mr. Das. I have given enough latitude to the state. You cannot say. Let him appear tomorrow. Tomorrow.
May I pray for Monday?
No. Tomorrow he will come. Tomorrow he will come along with and he will apprise the court by filing an affidavit. Tomorrow. And file an affidavit answering the query posed by this court in its order dated 25/6/2024. Yes. Kalyashiva.
Item number 19.
Please. Let's kindly come.
So the pleadings are complete.
Readings are complete. Provided my non-friends are ready.
We can begin. We can keep it aside.
That's it. Sir,
What are you challenging?
I'm challenging, in fact, the order rejecting my prayer, despite the order of the court to consider, and they have rejected now. So this case is like this. Way back in 2014, there was an advertisement for engagement of Shiksha Sahayaka. You know that only entry into the primary Shiksha Sahayaka. In that, when I made the application online, my application was not accepted on the ground of overage. These 3-4 cases same. Then we approached this Honorable Court. This Honorable Court disposed the matter, directing them to consider sympathetically, and they considered. They said that 5 years they will be relaxed, and the 42 years. Now, state will also may kindly come. The genesis of the case is like this. Page 23. Page 22 is the proceeding. Annexure 3. Proceeding of the meeting held on the chairmanship of the Commissioner cum Secretary. Page 23.
Yes.
These are all admitted records. Keeping the mandate of RT in view and taking the vacancy into consideration, the committee decided that the department will have no objection if the candidate beyond the upper age limit, that is up to 42 years, for general candidates with 5 years age relaxation for scheduled caste, scheduled tribe women, so and so, and 10 years age relaxation for the dated so and so are allowed by the Honorable High Court for consideration for their engagement. Then you also kindly come to page 24. This is the genesis, basis. On 37/2015, a decision was taken by the Government of Orissa Department of School and Mass Education. I'm not reading the whole proceeding. Let's come to just 6 lines from the bottom. And this has been communicated to OPEPA.
Yes.
OPEPA is the selecting authority. Government is the authority who has directed. Overage candidates, overage candidates, those who have applied online and obtained the positive direction from the Honorable Court, will be given the opportunity to select a district, if not engage in any district, having all other eligibility for the same.
Then your lordship kindly come to the next page, page 25. Because by this time, they have already proceeded to certain extent. Preference was given first, second, third, like that. So this decision was taken on 31/7/2015 with first paragraph of bidding, with reference to the subject cited above, I'm directed to intimate to that the engagement of eligible candidates in the post of Shiksha Sahayak during 2014-15 in their first and second preference choice district has been completed. Therefore, you are requested to prepare the merit list of candidate of their third preference choice district for the post of Shiksha Sahayak in your district, including the overage candidates, whose list has been submitted to the concerned DPO by SPO, or the candidate have submitted the orders of the Honorable High Court directly to DPC. Then, so far as we are concerned, let's kindly come to page 27, bottom, page 29. Page 27 starts, page 29.
Yes.
It is also decided, this is government decided, it is also decided that list of overage candidates who have applied through online and taken shelter in the court of law and a positive direction of the Honorable High Court, their cases should be forwarded to the district of their third preference choice as the process of second for the vacancies, preference and merit. There are large number of vacancies are there admittedly. Then kindly come to page 30. This is the of course, the extract I have given, which has not been denied. This is a list of overage candidates submitted by the concerned district. We are from Puri district. You also look to Sarat Kumar Ratha 916. Yes. So, yes, here is Madan Gopal Nandi and another, that is Kailash Chandra Shetty. These two persons are here. People also will see that from this, that third preference district that has been list has been prepared over its candidates. But the name is the matter.
পুরীরে ଦି ଜଣ ଅଛି
ପୁରୀରେ ଅଛି, ଅଙ୍କରେ ବି ଅଛି।
ଆପଣଙ୍କର କୋଉ ଡିଷ୍ଟ୍ରିକ୍ଟ?
ମୋର ହଉଛି ଗୋଟେ ହଉଛି ଜଣେ ଗଞ୍ଜାମ, ଜଣେ ହଉଛି ବାଲେଶ୍ୱର। ବାହାର କରୁଛି ଦେଖିଦଉଛି ତାଙ୍କ ନାଁ ଅଛି। ମୁଁ ବର୍ତ୍ତମାନ ପ୍ରୋବ୍ଲେମ ହଉଛି ଏୟା, ଆ ଭିତରେ କଣ ହେଲା, there are some other candidates, those who also stand in the same footing like us, they approach this honorable court before the honorable single judge. The single judge rejected their application, saying that you have not implemented parties. Petitioner also approached this court. They said that you have not implemented the selected candidate parties. That was challenging the writ appeal, and the judgment of the writ appeal in the batch of cases I have given at page 42 and Annexure 7.
Yes.
So also come to the last portion of the judgment.
This is the Babita Satpathy case.
Yes. And in fact, this writ appeal was filed by some other candidate, those who are also party to the writ application. But so far as we are concerned, we have not challenged that order of rejecting the writ application. Paragraph 12. On perusal of the material available on records and considering submission of the Land Council for both sides, we set aside the order. That means that order was set aside. On 29/11/2019, passed by Lord Single Judge in WPC number so and so, batch of cases. However, it is made clear that since there are unfilled vacancies of the post of Shiksha Sahayak available against which the appellant could be accommodated, we therefore direct the respondent to accommodate the appellant against the said vacant post as they are eligible for the said post. This judgment was challenged for the Supreme Court at the instance of the state. Supreme Court dismissed it. That is at page 54. Page 54.
Yes.
So after dismissal of that case, the contempt application was filed. They were, so for the person, those who are preferred appeal, they have implemented parties. So for the present petitioner are concerned, after the judgment was passed, pronounced by the division bench, petitioner approached the Honorable Court saying that that judgment has been set aside. Now, so far as the 2015 order is concerned, that we are overage candidate and third preference district, already we have come within that third preference. So our case may be considered. Now the order is passed, it also come to, and this court disposed of the writ application directing to consider in the light of the judgment. Now you also come to page, starts from page 56, that is operative person is page 58.
Yes.
Which is the impugned before us. In view of the region, the last part,
yes.
In view of the region assigned above, more particularly on the fact that the Honorable High Court specifically directed to accommodate the appellants on the above writ appeal, the benefit of the same cannot be extended in favor of the present petitioner. further the government policy doesn't permit to engage ineligible candidate. They say ineligible means overage candidate. So for the age concern, that has already been relaxed.
This, I think, hangs on one particular thread, which is whether that judgment is in rem or in persona.
That is one. Even let us forget for the time being that judgment is not a judgment.
You have the previous judgment. You are referring to the previous judgment.
Yes.
You have a judgment in your favor.
Right, sir. Themselves government has decided.
No, that was preferred by you. The 2015 judgment.
Sir, 2015 judgment I preferred by me and a batch of cases which were disposed of so far the overage is concerned. Yes. Overage is now condoned.
You are an overage person.
Sir.
So why do they say that they are ineligible?
That is ineligible. That is why I was asking Mr. Samal also.
Right.
How did they say that ineligible?
Have they not settled anything in the counter?
They have filed a counter.
Counter is not sufficient as defined.
How will the court can't imagine anything?
They have simply justified whatever has been
The
found.
only question for
No. I will, of course, they can't, on that ground, we can set it aside.
Finish sir, 15 যদি decision টা government নেইছে তাকে how can they ignore it? That is
What do you say? It has not been, and you can't even also add to whatever has been said in the original order.
Yes.
That oft-quoted judgment of Mohinder Singh Gill, isn't it? You can't.
You can't add something or subtract something which is not
Yes.
there in your bill.
So how they are not eligible? Can we just go to that order for a moment?
Finish sir 15 টা
से कोड लिख लीजिए तो कौन लिख रहे थे कोड लिख रहे
24 টা স্যার দেখুন পেজ 24 এইটাକୁ সে যদি মানে মনা করিয়ে দেলা লাগাতে if they say that this is the decision of the government how can they ignore it and এই বেসিসে তোমরা সব করেছো পেজ 24
I think this is all will close it. Now you want to.
In fact, in the counter affidavit, they have not said anything other than what is there.
You can't improve upon the case. Whatever was stated in the original improved order as well as in the counter. I think.
also close it. I will give a note of submission.
Hearing concluded, judgment is up. Parties may file their note of submissions and memo of citations, if any, within a week. So this will be a common order, I believe.
Except last case, after the judgment is pronounced, there are additional last case.
Acha, WPC 28493 of 2023 lists this matter on. We'll take it on 24th July.
Right.
See, good to go.
I give the note of submission tomorrow.
Said 1 week. Yes.
1920. Your Lordship, I'm filing my rejoinder, Your Lordship. Let me kindly be accepted.
Give it a copy. Give a copy. Learned counsel for the petitioner files rejoinder in the court. After serving copy, stop. Copy of which is also served on. Copy of which is served on the State Council in court. So we'll take it up on some other day. Place this matter on 7th August.
Item 21.
No, item 21, we are appealing for OP number 7, my lord. You need for a time to file counter.
He was appealing for the
Petitioner,
Mr. UK Samal.
my lord.
Prayer for adjournment is made on behalf of Sri UK Samal,
Souls of the mindset. I have also not filed a law.
on who appears for opposite party number 7. Learned State Council also requests for some time to file counter. List this matter August.
14th August.
On 14th August, counter affidavit, if any, be filed in the meantime.
Item number 22. Please, my lord. Transfer of diverse cases from Bhubaneswar to Berhampur. Petitioner is a deserted lady.
Who is appearing for the other side? Mr. Satyajit Mahapatra.
Sufficient.
No, somebody is appearing.
Yes, something
Does it appear?
Coming. Your old matter.
Sri Raghunath Das Mahapatra, the counsel for the petitioner is present. None appears for the opposite party on repeated calls. List this matter tomorrow. I just give one opportunity and then we'll. If he doesn't appear tomorrow, we'll dispose.
Item 23.
Present application is administration of the wife.
Yes.
For transfer of the
Koraput to Bhubaneswar.
from Koraput to Bhubaneswar.
You are appearing?
Yes, my learned friend is appearing.
Well, Mr. Purohit, why not settlement, mediation? I always ask.
Yes, it was sent.
It was sent for
It was
mediation.
sent, yes, failure.
Okay. Oh, all right.
So I think that 2 to 3 proceedings are Bhubaneswar. Marriage is solemnized at Bhubaneswar. Koraput is not the place of residence.
My lord, there is absolutely no cause of action for Bhubaneswar.
It will be transferred or cause of action?
My lord, किसी consideration नहीं, only cause he has shown that she doesn't feel safe in Koraput.
No, marriage is solemnized at Bhubaneswar.
No other thing.
Lady,
Neither have you any cause of action.
no, the lady's convenience is to be taken. You will be.
My lady is staying there in Indore, not in Bhubaneswar.
Family at Bhubaneswar.
Family, they have shifted to Bhubaneswar presently. They were not in Bhubaneswar. She was serving, they were serving there in Koraput.
Expert proceeding was going on at Koraput and it was restored now.
Anyway, everything is there in Koraput, my lord. The marriage was in Koraput. They have resided together in Koraput. Simply because her parents have shifted to Bhubaneswar, that is how she wants it in Bhubaneswar.
Also, the marriage was
No,
solemnized at Bhubaneswar.
Just a moment. If you yourself are not residing in Bhubaneswar, you are staying at Indore, then you can as well appear through virtual mode either at Koraput or at Bhubaneswar. How does it matter? I grant you liberty to appear through virtual mode.
Virtual mode, yes.
Yes.
There is no problem.
Virtual mode transfer can you?
Yes.
Exactly.
Therefore, transfer has been made by the petitioner wife of MAT case number 31 of 2022, pending before the Judge Family Court, Koraput. No, Jaipur. Koraput Family Court. No. It is at Jaipur.
Koraput is pending.
Koraput is pending over, sir.
Let
me see the plan. Civil Judge Senior Division.
Yes.
Pending before the Civil Judge Senior Division, Koraput.
Yes.
The Judge Family Court, Bhubaneswar. Stop. Such prayer is made on the ground that the petitioner's family is presently residing at Bhubaneswar, and therefore it would be convenient for her.
No, that ground also they have not taken.
Convenient for her to attend the court at Bhubaneswar than at Koraput. The Purohit Learned Counsel appearing for the opposite party husband has opposed the prayer for transfer by submitting that the petitioner herself is residing presently at Indore, though her parents are residing at Bhubaneswar. Having considered the rival submissions and taking note of the fact that neither the petitioner nor the opposite party is residing at Bhubaneswar, there is no justified reason to direct transfer of the case from Koraput to Bhubaneswar. Moreover, the petitioner can always appear through virtual mode by seeking necessary permission of the court.
Yes.
So, the transfer application is therefore disposed of, granting liberty to the petitioner to appear through virtual mode by seeking necessary permission of the court. Further, the court below shall not insist upon her personal attendance unless absolutely necessary.
So for other witnesses,
other witnesses. No, it is not applicable to others.
virtual mode facility can be extended.
No, virtual mode.
No, why the parents?
Parents
Our specific claim is that
anyway, if any application for appearing through virtual mode is made by the parents of the petitioner, the same shall be considered by the court below in accordance with law. Yes.
Item 24.
Entry mode of maybe back.
Yeah, automatic. Yes, item 24.
May I please, my lord? My lord, it's for transfer petition on the last occasion. In fact, before that date, the lordship was pleased to direct me to serve a copy on the state to be served on the husband.
Yes. Yes, state.
They took time to.
State. What happened to the service of notice?
So Pradeep Kumar, I have the information that I have.
To say that I can
Yes.
record your submission.
Yes, ma'am. The Pradeep Kumar certification.
Yes.
Yes. It has been sought upon him. ma'am.
Learned State Council submits
Produce
that
copy.
eh?
I'll produce that copy within the procedure.
submits that the notice of the transfer petition has been served upon the opposite party personally, as directed by this court. Yes,
Yeah.
there is however no appearance.
File that दिया है.
केबे टू हेलेनी
मैं आज को.
अच्छा,
एक बार
there is no however no appearance.
कुछ दी बात करते.
Learned counsel for the petitioner is present. In order to grant one more opportunity to the opposite party to appear, let's this matter, we'll give one more opportunity.
As your lordship pleases, ma'am.
To next week. Whatever interim order was passed, that will continue.
My lord, that much I pray.
Adjournment. Mr. Mishra.
My
Yes.
lord.
Item 25.
Obliged.
I am for the opposite party. I pray for not today only, next week or any other.
That I will do, but why not mediation?
Beg pardon only.
Why not mediation?
Yes, my lord. If your lordship pleases, then send it to me.
No, I said the court would like to peruse the FIR and the charge sheet of the said case.
Yes, ma'am.
The charge sheet has been submitted in the case instituted on the basis of the FIR lodged by the petitioner against the opposite party number 2 and her family members. So there was some allegation. Yes, got the charge. You file it? You file it? File the charge sheet? Today you want some time?
Yes.
File it? Then State Council submits that he has.
Charge sheet I will. By way of memo, I will give.
Yes, submits that he has obtained the charge sheet in the charge sheet and would like to and would file the same in course of the day through a memo. So, learned counsel for the opposite party requests for an adjournment. Let's this matter next week.
Obliged.
Item 26.
No, I have instruction to appear in this case for the opposite party.
Yes.
Opposite party husband. May I pray that let your lordship to take up this matter next week so that I will file my short objection.
Any chance of settlement, Mr. Bahali?
No, there is no chance. I talked to my client. There is no chance. Criminal case is also pending.
All right.
Case
All right.
is pending.
Sri BP Bahali submits that he has he has instructions to appear for the opposite party. We'll take it up next week then.
Yes.
Let's this matter next week. Yes.
Item 27.
My lord, this is a transfer petition. As per the last order, requisites were filed.
What has happened to the notice? Let us see. Proof of delivery of notice issued to the received after valid service. Office note indicates that notice on the opposite parties has been duly served. Learned counsel for the petitioner is present, but there is no appearance from the side of the opposite parties. In order to grant one more opportunity to the opposite parties to appear, let's this matter on number date. 31st July.
Item 28.
Instead of speed post, I have filed a requisite say registered post, my lord.
Why?
Order ta dekhi nathil huzurung order ta dekhi nathil.
More केवल speed transfer application में speed post. Requisites filed be accepted and notice be issued fixing a short returnable date. Let's this matter on
31st July.
31st July.
Item 29.
Yes.
In this case, on my basis of my proposals, I had thrice taken time. The middle place I had proposed the Kenduja.
Who is you are Dalai, Mr. Dalai, you are appearing?
Yes, ma'am.
But some Mr. Demardas was appearing.
Last time his associate was appearing, which was not well.
So it was said that you wanted to put for instructions from the client if the case can be conducted at Kyonjhar. What is your instruction?
Ma'am, post place in Koranjia, my lord. Koranjia Kyonjhar hochi 53 kilometer. Koranjia Bani hochi 150 kilometer NH 49 re. ତେଣୁ ଆମେ ରାଉରକେଲାରୁ ବଣେଇ ହଉଛି 63 କିଲୋମିଟର। ତେଣୁ ବଣେଇ ପିଲା ହେଇଛି
କରଞ୍ଜିଆରୁ ବଣେଇ କେତେ?
କରଞ୍ଜିଆ ବଣେଇ ହଉଛି NH 49 ରେ 150 କିଲୋମିଟର।
150?
ହଁ 3 ଘଣ୍ଟା 3.5 ଘଣ୍ଟା।
କେଉଁଝରରୁ? No, where are you residing now?
Bonegad.
You are residing at Bonegad?
ରାଉରକେଲା।
Raukla.
And she is serving as a bank employee, my lord, in bank. I am an assistant engineer in Karanjia.
Karanjia.
କରଞ୍ଜିଆରୁ ବଣେଇ ହଉଛି 150 କିଲୋମିଟର।
That's why
3.5 ଘଣ୍ଟାର ବାଟ।
Lordship Kenjor will be the middle person.
କେଉଁଝର ହଉଛି 50 କିଲୋମିଟର, କରଞ୍ଜିଆରୁ ହଉଛି 50 କିଲୋମିଟର, ମୋର ହଉଛି 200 କିଲୋମିଟର ବାଟ। ମୁଁ ଝିଅଟା ଯିବି ଏତେ ବାଟ ଆପଣ।
More problem is government employee.
Appear through virtual mode, and the court will consider the fact that you are.
More take instruction.
No, you will take instruction, but the court will also take into account because I'll say that your personal attendance will not be insisted upon because you are a government servant, and you can also appear through virtual mode.
Say the instruction I assume next week.
All right. Sri BP Das, Lieutenant Counsel for the petitioner requests for an adjournment. List this matter. 24th July.
Item 30.
Yes.
My lord, the petitioner is the wife of the opposite party. My lord, the petitioner is the wife.
Yes, Mr.
On behalf of Jagabandhu Sahu, I place this application. The petitioner is the wife of the opposite party. The petitioner seeking a direct
notice
notice was served and someone was appeared in this case.
Somebody has appeared? Yes, Mr. R.K. Samantrasingar. Sri Kesavula, Lieutenant Counsel for the petitioner is present. No, none appears on repeated calls. None appears for the opposite party on repeated calls. In order to grant one more opportunity to the opposite party to appear, list this matter on 31st July.
Interim order to
interim order को adjournment से लगी? Adjournment
Item 31. May I please?
To appear in this case for the opposite doctor. I'm filing the collective. Opposite doctor.
Major doctor serving and file the maintenance case.
Sri Chittaranjan Swami appears and submits that he has instructions to appear for the opposite party. Is this matter on 31st?
Interim order.
Okay.
Already interim order.
Interim order में सही adjournment?
Interim order to continue.
नहीं, adjournment से.
Item number 33.
Item 33 may please. There is two appellant, my lord, appearing for the first appellant, namely Bank of Behra. Lordship, here the charge sheeted under section 302, 201, 34 of IPC, Lordship.
I don't have the copies of the depositions, madam. Only judgment. ताको कॉपी नहीं चिंता
कॉपी दे दीजिए ना आउट दे दो उसको एक्स्ट्रा कॉपी डिपोजिट
Yes. Shall we take it up today or some other day?
Anyway, eyewitnesses are there, my lord. If your lordship wants.
No.
Next week, I will go through.
The other side, other counsel is also not there.
Yes, madam. That's second matter.
Copies of depositions have been served upon the state counsel in the court. Will this matter next week? Yes.
Item 34.
Pass over.
Item number 35.
Pass over.
Item number 36.
May I please? Filed an IA for external title to surrender for the non-trial court. The Lordship granted interim bail for a period of 2 months on 7/5/2024. Filed
while granting, your lordship called for the reports from the local police station. It was found that the mother of the petitioner was seriously ill.
It has already been extended by.
No. 7/5/2024, and the period subsequently he released on bail, and it will expire on tomorrow.
2 months. He has been released for 2
Correct.
months.
Some her mother is 82 years, father.
It is submitted that the condition of the petitioner's mother has not improved. And she requires further treatment. Considering the submissions as above, the interim bail granted by the related so and so is extended by a period of 1 month.
One small prayer, madam. Tomorrow is the Sunday, can you upload?
Urgent copy be granted in course of the day.
Item 37.
Fix a date.
1 month.
No, listing
Disposal.
or disposal. Well,
Please, your lordship.
yes.
Your lordship, on last occasion, asked my learned friend to obtain instruction with regard to the element as well as the affidavit filed. I filed an application for interim bail. The lordship
Yes.
directed.
What is your instruction?
I have taken instruction from the jail authorities as well as from the house owner. Jail authorities, they have stated that he is only suffering from diabetes. And the house owner, he was surprised when sees that agreement that the signature is not the owner.
Forged.
Yes, ma'am. Signature is not.
Then don't press it. Mr. Das, don't press it.
No, my lord. If it is so, then I have.
No, I know. You are a good counsel, Mr. Sir. Don't do that. Please. Otherwise, I'll pass an adverse order.
No. Why should I invite with you?
No, not that.
This is how they.
You have a different status altogether. Why should you indulge in all these things?
My lord.
Man, State Council. I'll dismiss it on that ground.
Wait,
I'll reject
to
it.
withdraw. If your lordship allow me.
No.
That interim application I am withdrawing because I was filing that basing on the documents supplied by the medical. I mean the
Lower Court Council.
No. Jail. Jail asthela jo document
No, rent agreement. Rent agreement.
Rent agreement by the son. So I am withdrawing. What I was, in fact, I was making query from him. They were residing there. Upon his arrest, this son is prosecuting at Uttar Pradesh. Very intervening time, they are visiting this house. Most of the articles they have taken away. That was also.
Yesterday, I have granted regular bail to an outsider, even though I don't grant. Because he was released on interim bail. He appeared on each day of posting of the case, did not violate any condition. And he had stayed for more than 3 years. It's not that I am closed my mind.
It will be good in Rohilani, but on this application, I am withdrawing my.
The bail application should be rejected on that ground.
Withdraw କରିବାକୁ ଦେଇଦେବେ ଆଉ ରିଜେକ୍ଟ କାଇଁ କରିବି ମୁଁ ଆଉ ପରେ ଆସିବି କାହିଁକି ନା ମୁଁ ବି ରହିଲେଣି ବହୁତ ଦିନ
I'll record it, but
3 ବର୍ଷ ରହିଲାଣି 3 ବର୍ଷ ରହିଲାଣି.
London State Council has obtained instructions that the instructions from the jail authorities that the petitioner is suffering from diabetes.
Diabetes, those records are on record.
Diabetes. However, insofar as
the jail doctor has said it is uncontrolled. That's the word. Page 31, 32.
Insofar as the rent agreement is concerned, the same appears to be not genuine, as the house owner, so-called house owner, disowned the signature appearing on the rent agreement, purporting to be his. At this stage, Sri S.K. Das, learned counsel for the petitioner, seeks permission to withdraw the bail application.
Because it was within the interim thila jau say because of his
conduct.
Yes,
bail application is dismissed as withdrawn. We cannot permit any kind of.
No, my lord.
Yes.
Item 38, pardon, my lord. That previous matter, item 36.
That is, noting is there, the case adjourned to week commencing 15/7. ऐसे कोई पढ़ेले dispose of है.
आइए dispose of है आइए dispose of है 38.
My lordship, the third bail application matters. First application, your lordship, was after examination of victim matters. And the second bail application, your lordship granted interim bail matters.
So,
Law affairs matters, division,
they granted you interim bail for 2 months.
matters.
You should be satisfied with it.
Because victim has been examined and she has.
Yes, yes.
Yes, ma'am.
That is why we granted him interim bail.
Madam, PW2.
Now you want interim bail for on what ground?
My lordship, surrender. After 2 months, he was surrendered.
Petitioner is in custody since 24/4/2021 in connection with such and such case. His earlier bail application was rejected, granting him liberty to renew his prayer after examination of the victim. Stop. After the victim was examined, the petitioner was granted interim bail for 2 months by this court. As per order passed in BLAPL number 9278 of 2023. The petitioner surrendered in time without misusing his liberty. Now, the counsel for the petitioner submits that trial is progressing slowly and the petitioner has been in custody for more than 2 years. Under such circumstances, he should at least be released on interim bail. Now, the State Council has opposed the prayer for bail by submitting that the victim has implicated him in her deposition, in her testimony. Considering the submissions, the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 2 months.
39.
That's all.
I don't know, 40.
That's all.
Item 41.
May I please your lordship, my lord, custody since 20/02/2024. Offense alias 0234 IPC. My lord, found not eyewitness for occurrence. Present petitioner is Kariya Deepak Sahu. My lord, co-accused person are religion bail. BLPL number 10,721. Present petitioner is on same footing, namely Mamata Sahu, Suhasin Behra, and Goji and Basanti Sahu. My lord, allegation and petitioner have not been in a fair, nor by person who
Yes, there is, but preliminary charge sheet will be Tana. Though I have taken instruction, final charge sheet has been filed. So I have to verify whether what is the role of the petitioner.
Up to date case diary, including the final charge sheet.
Yes,
Filed in the case be obtained. Let this matter in on 31st July. Yes.
Item 42.
49. Yes, pass over.
Item 43.
May I please, in this case, I filed an IA for modification of order. In order sheet, my lord, order dated, my lord, 2/7/2022 instead of 2/7/2024.
The order will be corrected
And
as 2024.
and in cause title, my lord, petitioner district instead of Koraput, it was typed as instead of Malkanagiri, it was typed as Koraput.
Correct. Correction being made.
Cause title bhule jaye Koraput
Yes.
Malkanagiri.
Item 44.
May it please your lordship, NDPS case in custody since 8/9/21. Your lordship had called for a report.
As per report submitted by the court below, 4 out of 15 witnesses have been examined so far. The petitioner is in custody since
8/9/21
8/9/2021.
and 23 years of age, local male.
It is alleged that petitioner ସହିତ ଆଉ କିଏ ଥିଲା?
ଆଉ ଗୋଟେ ଥିଲା ସେ କଣ ଦେଇଛି ଯିଏ ଦେଇଥିଲା ପଇସା କିଣିବା ପାଇଁ ସେ ବୋଧେ ଗଲାଣି।
The petitioner and another person were transporting contraband ganja.
ନାଇଁ ଟ୍ରାନ୍ସପୋର୍ଟିଂ କରୁଥିଲା ଏଇ ଜଣେ। He said that
He is the sole person to be. The petitioner was allegedly transporting contraband ganja in an auto rickshaw when he was apprehended by police. It is submitted that despite being in custody for nearly 3 years, the trial has not concluded and is progressing slowly. The petitioner may therefore be released on, at least on interim bail.
ଆଉ interim କାହିଁ ଦେବେ?
After perusing the report of the court below, this court finds force in the submission of learned counsel that the trial is indeed progressing slowly, which affects the fundamental right of the petitioner to speedy justice guaranteed under Article 21 of the Constitution of India. Under such circumstances, I am inclined to allow the prayer for bail. Let the petitioner be released each day appearance.
Item 45.
Yesterday I provide the FR and 161 statement of.
Easily? Yes,
Yeah.
fine. Dear.
Court to the end. I have gone through my lord. He has not been named in the affair. And the petitioner also, the victim also not implicated in her 161 statement.
Okay. This is a 364 matter.
Yes, 370, 370A.
All right. The petitioner is in custody since?
16/4/2000.
And he is similarly placed to one Prashant Kumar Sethi. Yes, my lord, similar. Lordship granted.
All right, same order. ये रखो, रिकॉर्ड रखो। अच्छा, हो गई।
Item 46.
Please, your lordship. I am there virtually.
Yes.
Lords, here I am in custody since 26th of September 2021, my lords. In a case under section 147, 148, 341, 323, 326, 302, 120B, read with 140.
You have the case diary?
No, my lord, case there is not there. I think there is a typographical error or what, I don't know. Prayer is for interim bail.
Prayer could be for interim bail.
Oh, then it's a typographical error, my lord.
Why should I take it as a typographical error, Mr. Ponda?
That is the
a lawyer of your stature is not expected to commit such mistakes, so I will take it as a conscious decision.
Sometimes I believe that my associates are.
No, why should I? The court will presume like that. Anyway, let the case diary come.
My lords, the case diary, my lords, is available in a connected matter. In fact, yesterday your lordship granted interim bail in that. BLAPL 8746 of 22.
I will verify, man.
8746 of 2024. Next one, Sitru?
I will verify.
All right, up to date case diary be open. Let this matter on 24th July.
My lords.
Yes.
It is 8746 of 2023.
23. Yes.
Item 47.
May I please, lordship? So the petitioner is the legal married wife of the opposite party for a direction to transfer the mat case no पंचायत from the law.
Some change in the nomenclature?
Sir, nomenclature sir change ହେଇଯାଇଛି sir.
ହେଇଯାଇଛି? All right.
Sir, ଆଠଗଡ଼ରୁ ବାଙ୍କିକୁ ଆସିବ transfer ହେଇ.
Notice ଯାଇଛି?
Sir, notice ହେଇନି.
No, it has not been changed as yet.
Sir, CRP ହେଲା ପୁରା. Sir, CRP ହେଇଛି sir.
It has come as CRP?
Yes.
No. It is CRP change ହେଇଯାଇଛି. ଠିକ ଅଛି. All right. CRP ହେଲେ CRP हो ट्रांसफर का ना TRPC हो TRPC हो ये भूल कर दीजिए since this is a transfer application the nomenclature should be TRPC. The order dated 26/2024 is modified by substituting the word CRP occurring in paragraph 3 as TRPC. Office to carry out the necessary corrections and list this matter next week for admission. Yes.
তাহলে স্টেটা রহো তাহলে সেপটে প্রসিডিংটা স্টার্ট
In the meantime, if any application is moved by the petitioner in the court below, the same shall be considered, having due regard to the date of hearing fixed for this case. Yes.
থ্যাংক ইউ স্যার হবে স্যার
48,
Correction being made accordingly.
item 49. Governed by the effect of the last occasion, my lords, Korea FIR has been lodged or not. So my instruction perhaps she has gone for the police station, but police is refused to receive the FIR.
তাহলে আপনারা WPCRL ফাইল করবেন
সেটা সেদিন অ্যাডভাইস করছি যে
ওই অ্যাকাউন্ট করে দেবো উইথড্র করে
লিভার টু ফাইলে বেটার অ্যাপ্লিকেশন নেক্সট
বেটার অ্যাপ্লিকেশন
এটা উইথড্র করতে
উইথড্র করে আপনারা কি মনে করছি ফাইল করে ইউ ডোন্ট হ্যাভ দেয়ার ইজ নো রেস জুডিকেটা ইন দ্যাট ইউ ক্যান ফাইল এনি টাইম ইউ ওয়ান্ট
another court said you have not get the liberty, so therefore my own solution.
All right, permitted to withdraw with liberty to file a better application. Yes.
I may be part.
Yes.
In item 18, your lordship directed the personal appearance of the director elementary education, but I had prayed for 2 weeks' time because of the letter from the DEO, Kotak. So your lordship may direct the DEO to be
DEO is not a party. I found that DEO is not a party. He is a small time officer. Why should I call him? Let the director.
In fact, he had requested for 2 weeks.
No,
time.
why will he take granted? Why will he take the High Court for granted?
No, because he has stated the reasons. Because the matter relates to very old incident of 2006 and 7. So he has requested for 2 weeks' time to get those relevant records, and so your lordship may seek direct the DEO Kotak to remain present at 10:30 tomorrow.
All right. सीधे जो डायरेक्टर एलिमेंट्री एजुकेशन एजी आइटम पेरेंट्स ने कर ली जो कौन डिस्ट्रिक्ट एजुकेशन अफसर कर देते
Pertinent issue. Item of
DEO Kotak.
ब्लॉक एजुकेशन अफसर कर दो
Obliged. District.
500 করে লাঞ্চ
Lordship, in item number 35, my name is showing. That is already a matter that has been finally disposed by, my lord.
It has been going infructuous item.
Yes, Lordship, item number 35.
It has been disposed.
Yes, Lordship, it's a disposed matter. I just saw my name, that's why I.
No, there's an IA. There's an IA for appropriate order. Why? Wrongly listed probably.
Yes, Lordship, I have not filed any such IA, my lord.
All right. Since the matter has been wrongly listed, it be delisted.
I'm obliged, Lordship.
IA ରେ ତାଙ୍କ sign ଅଛି ସବୁ ଅଛି file well IA ରେ ସବୁ ଅଛି ତାଙ୍କ sign and number mail ID ସବୁ ଅଛି
Adjournment, your lordship. Appeal has been admitted and injunction has been granted. And I have taken consent from the respondent advocate.
You have not taken the consent of me.
Sorry, your lordship. Right.
My consent has not been taken so far.
Sorry, your lordship.
55.
Yes, your lordship.
2023 matter. When do you want?
2 weeks after any date.
Will this matter 2 weeks after?
Interim order to continue.
তাহলে ডেট করে দেবো, হ্যাঁ?
Commencing 5th August.
Week commencing 5th August. Yes. Item kete?
Item 34.
34, your lordship.
Item
Last
34.
occasion, lordships, director to take instruction regarding the health condition. Health condition.
Yes. I got 10 mark. Backside the jail. Yes, what do you want?
I file for entering by your lordship.
Interim bail. Leonard State Council has obtained instructions from the medical officer, District Jail Puri, being forwarded by the superintendent. Said report indicates that the petitioner is suffering from a host of ailments and that his major treatment is required at SCB, MCH, neurology, endocrinology departments. Such super special treatment is not available in the Puri jail. Having regard to the above fact, this court is inclined to take a lenient view. Let the petitioner be released. Ko ayeta kete?
764, your lordship.
Let the petitioner be released on interim bail for a period of 2 months.
Obliged.
Further extension. Already for 5th time. So item number 39.
None appears. Is this matter when moved? Yes.
So item number 40.
Pardon, your lordship. From the date of release, your lordship. 2 months from the date of release. your lordship.
Well, that's the usual order which is being passed. Yes.
Item number 40.
My lord, here, the petitioner is in custody since 26/1/2020.
Earlier rejected by Justice Sahu.
But
Isn't it?
first bail being granted by your lordship, it has come.
I've granted him interim bail
Yes, he has surrendered in due time.
for 3 months.
Yes, he has surrendered in due time and complied, your lordship.
Yes.
My lord, I am in custody since 26/1/2020.
Yes.
My lord, the prosecution case is 2 vehicles were involved. One was motorcycle and one was auto rickshaw. The present petitioner was in auto rickshaw. There is no dispute on that.
Should we go to the merits once it has been rejected on merit? Why should we go on merit?
No,
You may validly say that you have been in custody for maybe 2.5 years.
I have complied your lordship's order, and the Kartik Sabar, who was
All right.
he has been granted regular bail.
The trial is going on almost.
Yes, out of 29 witnesses, 5 witnesses have been examined. 4 witnesses.
The petitioner is in custody since 26/1/2022 in connection with such and such case. It is alleged that it is submitted by Sri A.P. Bose, learned counsel for the petitioner, that trial is progressing very slowly, in as much as only 5 out of
4 witnesses out of
29 witnesses have been examined so far.
23, I'm sorry.
23. Witnesses have been examined so far. The petitioner has spent more than 2.5 years in custody by now. There is no likelihood of the trial being concluded in the near future. He was earlier released on interim bail as per order passed by this court in BL appeal number 9987 of 2023. And he surrendered in time without misusing his liberty. It is further submitted that detention, submitted that prolonged detention in custody without trial being concluded violates his right to speedy trial guaranteed under Article 21 of the Constitution of India. Learned State Council has opposed the prayer for bail by submitting that the quantity of contraband is huge and therefore no leniency should be shown to the petitioner, Tara. Having considered the rival submissions and taking note of the fact that the petitioner has spent more than 2.5 years in custody by now, and there is no likelihood of the trial being concluded in the immediate future, this court feels that the fundamental right of the petitioner to speedy trial stands violated. In such view of the matter, I am inclined to allow the prayer for bail. Let the petitioner be released. Each day appearance.
Grateful. So right now 42.
42.
Right, the lordship turn to the affairs at page 10, my lord. Right, initially, the affair was lodged by one Sagar Das. Deceased is his brother, my lord.
I have rejected it. I have rejected it.
Rejected.
After referring to Sagar Das's deposition.
What happened, my lord? Your lordship turned to page 10, my lord. The affair was lodged by the brother, my lord, the Sagar Das. He has not stated anything so far as the petitioner is concerned and others omnibus in nature, my lord.
No, I have, you see, this is my last order.
Yes.
From the copies of depositions of the said witnesses, it is seen that Sagar Das has directly implicated the petitioner in the alleged occurrence. That is why I rejected it.
That is, my lord, your lordship, affair, your lordship, specific, he along with others have assaulted as per deposition, my lord. Yeah, he has related, he is the brother of the deceased, my lord. But independent eyewitness, my lord, he turned hostile, my lord. He does not support the case, my lord. And 3 years he is in custody. For some days, your lordship may consider, my lord. That's right.
କିଛି ନାହିଁ ନାହିଁ କେସରେ କିଛି ନାହିଁ ଗୋଟେ ମିଛରେ ଖାଲି ଲୋକଙ୍କୁ ରଖି ଦେଇଛନ୍ତି ଆଉ
ନାଇଁ ପ୍ରଥମେ ଆଜ୍ଞା କିଛି କହିଲେନି ଯେହେତୁ ତା ଭାଇ ସେ ସ୍ପେସିଫିକ କହିଦେଲା ଏକ୍ସ ୱାଇ ଜେଡ୍ କରିକି
ତା ଭାଇ ମାନେ ଯିଏ ମାରିଛି ତାଙ୍କୁ ଛାଡି ଦେଇକି ଅନ୍ୟ ଲୋକଙ୍କ ନାଁରେ କହିବ
ଅନ୍ୟ ଦେ ତାଙ୍କୁ ଛାଡିଦେଲା ଆଜ୍ଞା they have been discharged from charge sheet. Your lordship kindly see the
anyway I have passed an order on consider
some days your lordship consider, my lord.
Yes.
Directly implicated and what role was played, that is also there in the deposition.
You have the copy of deposition?
Yes, PW 8 is the information.
Sagar Das.
Examination para 2 and the chief para 2, now para 6.
Para 2, your lordship kindly deposition evidence of.
Yes, it clearly nagoes. Santosh Das, Dakko Das, Kuna Das, along with one Ranga Das and other lady persons had attacked us by means of sword and tanga. All the 3 accused persons are assaulted by dealing blows by means of sword and kati.
Yes, stated 5 person name. Thereafter 3 person.
Cross examination para 6.
Para 6.
Yes.
No, Ranga Das was holding one kati, Kuna Das one sword, Dakko Das and Santosh Das were holding kati. How came to koithanda?
Hey, para 2 re. He named 5 person, my lord. Santosh Das, Dakko Das, Kunna Das, along with Ranga Das and other lady person had attacked us by means of a sword and thenga. All 3 accused.
Apa cross examination re tadu nei asle ki kon dortila ko se koi dela? You means
3 years roile.
You have seen the
consider for some days, my lord.
This is a case of murder.
Retrieve upon reject करछन कि 3 years roile.
This also reject करिବି.
କିଛି ଦିନ ପାଇଁ ଦିଅନ୍ତୁ interim bail
କଣ ପାଇଁ interim bail କଣ ପାଇଁ କୋଉନାନ୍ତି ଗୋଟେ କାରଣ
3 years, my lord. Poor father mother are there, nobody.
Yes, what do you say? Who are the eyewitnesses have been examined?
Yes.
All right, the petitioner.
9 para
Say.
The petitioner is in custody since
19/9/21.
19/9/2021 in connection with such and such case. His earlier application for bail was rejected by this court, considering the fact that the eyewitnesses have directly implicated him in their evidence. Learned counsel for the petitioner, however, submits that because of delay in conclusion of the trial, the petitioner is unable to take care of his old and ailing parents. Stop. Learned said, therefore, he may at least be released for some days on interim bail. Learned State Counsel has opposed the prayer for interim bail on the ground that a strong prima facie case exists against the petitioner. Considering the rival submissions and taking note of the fact that the petitioner has been in custody for
About 3 years.
For nearly 3 years.
Near about 3 years, 2 months.
Nearly 3 years, 3 years, and there is no likelihood of the trial being concluded in the near future. I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of one month.
2 months. 10 years. Oblige.
39. Yes, certainly it has been called out thrice.
No, my lord, I was a little bit busy with the medical for that reason, my lord.
So I am also busy with my, my board. I have a long board to.
No, I'm sorry.
Jaldi kaun.
My lord, please, lord. Eta group 4941 of 2022 रे dismiss for default ହେଇଥିଲା plus CRLM भी गोटे withdraw ହେଇଥିଲା. CRLM ମୁଁ ଫାଇଲ କରିଛି ନୂଆଟେ ଆଉ ଗୋଟେ with limitations. ତା ସାଙ୍ଗରେ ନୂଆ ବିଲ୍ ଟା ଆସିଥିବ 3863. हजूर 3863 टा सुनिबे पूर्वरु 4841 टा आउ जने एडवोकेट थिले से विथड्रॉ कर देथिले CRLM टाको एटा 3863 टा
So you have to restore the earlier application if it has been
फाइल कर दीजिए CRLM में with limitation भी फाइल.
So let the CRLM come. Let the CRLM come. How can, when that is pending, how can this matter be taken up, Mr. Mishra? Is it not? Will it not be a technical?
CRLM attach ହେଇଯାଇଛି ସେଥିପାଇଁ.
No. CRLM can be attached. CRLM ଆମେ ଶୁଣିବେ ତ
124 of 2000.
ଆମେ dismiss କରୁଛୁ ଆମେ ଶୁଣିବେ नहीं. It is submitted that no, list this matter next week along with CRLM
number 124 of 2024.
124 of 2024. So if that is restored, you can withdraw this.
My lord, along with limitation, IA number.
Then IA pays that you see and if that application is taken up, then this application has to be withdrawn. Yes.
Oblige.
Okay. Weekly. Weekly कितने change आये
33.
33. Okay.
Weekly list item number 33.
Your Lordship may kindly pass over it for the day.
All right, pass over.
Weekly list item number 34. 34, Your Lordship, last occasion issued notice to the respondent on the question of admission and stay the proceeding.
So that
matrimonial dispute, Your Lordship.
So you showed me one judgment probably.
Lordship, that section, Your Lordship.
Yes.
That's
section 19.
Yes, Your Lordship.
So that is, it is maintainable.
Yes, Your Lordship. And my learned senior friend appearing for the respondent wife, Your Lordship.
So it has to be remanded.
It has to be remanded.
Ultimately, it has to be remanded unless you have any objection to what he's submitting about the maintainability.
Yes, there is a Supreme Court passed the order. The time period is 15 March 2022, 28 February 2022. After 1 year and 4 months, they have filed. 1 year.
Before the first appeal.
Yes, sir.
So that first appeal.
They have not explained the date and time. What is the problem? They have not explained properly. That is the only grounds.
What is the main case?
Main case, Your Lordship, the present respondent file a proceeding under section 25.
No, before Mr. Bhuiyan, before you proceed further, let me ask one question.
Yes.
Since it's a matrimonial dispute,
yes, sir.
Can you think of mediation?
No, it's already.
You may take
fail, Your Lordship.
Mediation fail for a matrimonial dispute till the last day the Supreme Court also you can have a conciliation.
Hike the maintenance.
the file the only the hike the maintenance.
Divorce allow hegala.
It is the legally married wife and the earlier maintenance in 2004, 3,000 only. Now the receive the salary 30,000.
Lots.
Is the legally married wife. And
Maintenance ଯାହା award ହେଇଛି ତାକୁ ତ ଦବାକୁ ପଡିବ
and
ସେଥିରେ
that was a hike 5,000 also. This is the case. And they file according to 28 sub 2, there is no any embargo. The present situations and the hike situations. So according to this, they have passed the order and only hike the 5,000 only. And that is the 30. And is the respondent is the legally married wife.
So this order of the sub-judge is for payment of
Maintenance.
3,000.
The maintenance has been varied.
5,000 each, brother?
5,000.
5,000 each. So you challenge this before the...
No, I am not challenging that. I am challenging that before the learned sub-judge, the proceeding is under Hindu Adoption and Maintenance Act.
Yes.
But the learned sub-judge has taken up the proceeding as Hindu Marriage Act, Section 25. I am saying that he should not have, he would not have. Because the proceeding under Section 25 Hindu Adoption and Maintenance Act and Section 25 of Hindu Marriage Act totally different, Your Honor. And there is no appeal lies as against Hindu Adoption and Maintenance Act. And for that reason, I challenge that before this Honorable Court in matrimonial appeal, which this Honorable Court says this proceeding is not maintainable, you file it before the learned additional district judge, concerned additional district judge. That order has passed on my absence before this Honorable Court, and ultimately when I come to know, I withdraw the petition and file it before the learned additional district judge, and learned additional district judge has rejected my petition only on the ground that the limitation. My respectful submission is that when the proceeding is under Section 25 of Hindu Adoption and Maintenance Act is pending before the learned trial court, the learned trial court has categorically hold that the previous proceeding
we cannot go into other aspect.
I bow down to that. যদি এটা সেটিকে রিমান্ড হয়ে যায় কি আফ্রেশ শুনানি হয়ে যাব সেটা
नहीं afresh শুনানি যদি भी হবো I don't know whether I'll pass
ইয়ে করনি
whether I'll pass that order or not I don't know but for in case you have to pay whatever you admit to be the maintenance.
Yes.
It is 3,000 student ticket. According to it is 3,000.
3,000.
So go show proof to the court that you have paid.
Let my learned senior friend take an instruction. I am paying 3,000. অবিকা কথা হলা কোন যে 5,000 এনহান্স কর দেলে সবজো যে অর্ডারটা এনহান্স গলে সে যে 2,000 রেসিডিউটা রয়ে গেলা সে 2,000 টা it is right now staring on me 2,000 from the date of pay. That is my whole submission.
As I understand your case is that there was an earlier compromise.
Yes.
As per which she agreed to take 3,000, receive 3,000.
Yes.
Now ignoring that the subject passed a 5,000 rupees order.
That order was 2004.
Well, all right.
Prevailing situations, they enhance. There is no bar. Account 25.
The question is whether it is an enhancement or a fresh order. That has to be seen.
They enhance.
That's all right. It has to be seen. And there is also a legal point being raised by the appellant that he could not have taken recourse to the provisions of the Hindu Marriage Act.
There is no bar.
No, it's not a question of bar. Sati, Suno. The legal point that he is raising is that the application was under Hindu Adoption and Maintenance Act. But he has proceeded as if he was dealing with an application under the Hindu Marriage Act. You don't worry about the maintenance. Maintenance will be paid to you.
But in the previous now situation,
Aja, suno to maintenance, sir, suno to. Apan suno to. The maintenance will be continued to be paid to you. Whatever undisputed amount will be at least paid to you. Till it is decided by the additional district. In the meantime, you obtain instruction about that. What do you say?
That 3,000 rupees I am paying every month.
So you bring that information, instruction, or obtain instruction.
Can more instruction I am paying.
Counsel for the appellant submits that. No, I'll finish it by next week. Don't worry. Next week, sorry, you. Sri Bhunyal and counsel for the appellant submits that his client has been regularly paying the undisputed maintenance amount of rupees 3,000. Learned counsel for the, you are Mr. Jena.
Jena.
Sri NK Jana, learned counsel appearing for the opposite party, disputes such submission. By submitting that the petitioner has not regularly paid the maintenance amount. He further seeks time to obtain instructions in this regard from his client. Place this matter next week. It will come in the admission stage, it will be disposed of. The parties agree that the matter can be disposed of at the stage of admission. Interim order passed earlier shall continue till the next date. Next week, yes, or you obtain instruction? And on that also, if you can have a settlement, well and good. 2004 a compromise 2024 it can again happen.
Yes.
You say, you decide. Out of court, if you decide, well and good. Otherwise, I can also send it to mediation.
Okay.
Anyway, 35.
Item 35.
Very good. Yes, 35.
Just before the starting,
Yes.
Jitan Mundu and Saban Mundu, they are cousin brother.
Yes.
Cousin brother had taken 6 lakhs rupee loan from the Jitan Mundu. Saban Mundu has taken loan from the Jitan Mundu. 6 lakh. On the date 2/12/2008. On the same date, they executed one agreement. The agreement mentioned that the money will be refunded within 10 years, and first 4 years, Jidan Mundu, Saban Mundu has to pay 1,000 per month as pocket money, and after 4 years, if he could not pay, then 2,000 per month. After the 4 years, the husband, Jidan Mundu expired. When Jidan Mundu expired, he did not give 1,000 money. Here, his wife, Jidan Mundu wife, here plaintiff and appellant demanded loan amount. Being that they are cousin brother, the mother of the Jidan Mundu knows to the Saban Mundu. Saban Mundu insisted the mother of the Jidan Mundu to file 125 CFPC for maintenance. When maintenance case was filed in the family court, Hon'Ble Mundu, the plaintiff, appeared the family court, and Saban Mundu also came there as a witness. At the family court, the appellant Hon'Ble Mundu asked cross question whether you have made an agreement for the loan amount. The judge, family court judge, has written in the page number 89.
To cut short your long argument, the suit was dismissed. It was held that the plaintiff is not entitled to recover the amount.
Yes.
Yes. Then what happened in the appeal?
Appeal, the one document, main document, was not taken into consideration.
Which one? Which is the document?
This document is page 89.
This is a deposition. 89 is deposition.
Deposition. Deposition, dependent had admitted he had taken loan and executed one agreement. Everything was there, but trial court or appellate court, lower appellate court, has not taken into the consideration.
No, he says I had.
Jidan Mundu and also 6 lakhs from the Jidan Mundu.
Yes.
And the court taken the 4 lakhs as a loan amount from the mother and 6 lakhs did not consider. That is why rejected.
So on factual. This is what the court holds. The defendant has neither Salome Mundu, salary, amply fortified exit, transfer of money to the account of Salome regularly, and the plea that he had taken money from her and repaid the same to her, that he has proved his plea regarding. No, the court holds that the defendant has repaid the borrowed amount.
Defendant has not paid. This is manufacturing document. I have said in the court, and manufacturing document I have also filed here. Manufacturing document, how?
What is the manufactured? Which one is the manufactured document?
WS file, page number 100 to 124.
Okay.
After the filing of WS. WS file 3/4/2018. But money receipt was filed after the WS. Sorry, those two such a page, after filing this, page number 100 to 124. WS was filed 3/4/2018. A second thing, WS says I have already paid 2 lakhs during the admission of the Jidar Mundu was expert due to cancer. He was admitted in the hospital. At the time they admitted, I had already paid. Means 2012. 2012 I have already paid. But here money sheet shows 2000 after the 2018. And who received? She has said, I have, there is no document evidence.
These were exhibited before the court below. These documents, the money receipts.
Objected. These are exhibited but objected.
No, objected maybe.
How it is possible? WS, after the filing of WS, money sheet has been prepared and filed. One thing is in WS, other thing, one thing is the money sheet.
You are Mr. Ramesh Kumar Sahu. Third Sri Ramesh Kumar Sahu, learned counsel for the appellant. Peruse the impugn judgments. Considering the grounds raised, the second appeal is admitted on the following substantial question of law. Whether the finding of the court below is perverse, being contrary to the evidence on record regarding the loan agreement. That's all. Issue notice to the opposite party by registered post with AD. Opposite party respondent. Returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter on.
In the week commencing 9th September.
In the week commencing 9th September. Yes.
Item 36. Item 28 yesterday was passed over. I am for the respondent. Will your lordship take up?
Yes, sir. Yes, sir.
Your lordship may pass over this matter.
Well, it passed over for the day. Yes, Mr. Bose, before I go to the hearing, what is this matter? Why was it passed over?
Well, yesterday appellant took a pass over.
Okay.
28 I am for the respondent. My senior Mr. Bhuya is also there.
You want to,
We are for the respondents.
We are all for the
who's
respondent.
for the appellant?
Mr. Senior Mr. SP Mishra.
Mishra is engaged in this matter, that's in item number 28 for the appeals.
Okay. So he's not there. So we'll pass it over.
Sir, thale kali pardon no rakhi aro week ke ta paro week sir some other day.
All right. Release this matter next week.
Sir, thale 22nd week re asu jodi
All
apna
right.
asubidha no.
We'll be commencing 22nd.
Sir. So, appellant not admit respondent
Yes.
Item number 37.
37. Yes. All right, pass over.
That's my learned senior, Mr. SP Mishra is argues it be passed over for
All right, pass over.
Item 38.
Pass over.
Item 39.
39 as well.
Yes, pass over.
Item number 40.
It is the respondents are at the time filing of the second appeal is around 75 years. Right now they are 1992. They have already written later, but no. My lord, respondents are at the filing of second appeal at 75 years old, my lord. Two of the respondents. Right now they are 92 around, my lord. We have communicated them. But
You are for the respondent.
appellant, my lord.
Appellant. Okay.
Whether
So,
they are alive or not, we have no instructions since more than.
but you said just now that you had communicated with them.
We have communicated written a letter, but no reply has come, my lord.
I think we can take up this matter. Yes, Mr. Pradhan. You are for the respondent. Okay. So then,
Management of the school.
so it may not be, it may have become infructuous also. Nahi, see, infructuous hai ye to. You take instruction, we'll take it up next week.
My lord, one more week, my lord.
All right. Let's this matter in the week commencing 22nd July, as prayed for by counsel for the appellant. Yes.
Obligation.
Item 41.
Your Lordship, this second appeal has been preferred against the reversing judgment. The appellants of the second appeal were the defendant number one.
The other side? Who is for the other side in this case?
Other side say appearing Kailash Karo. He may not come. So I requested him minimum 4 times.
No, let us hear it part. We'll keep it part. I will keep it to next week. If it doesn't appear, I'll dispose of. I will not wait. 2010 matter, I will not wait.
No,
Name, I will begin. Yes.
So your Lordship, the appellants of the second appeal were the defendant number 1 and 2 before the trial court in the suit, and they were the respondent number 1 and 2 before the first appellate.
So who is the appellant? Say again.
Karuna Sethi and
Who are they? They were the plaintiff or the
defendant.
They were the defendants in the suit.
Yes.
Suit was filed for?
Appellants.
Suit was filed for what?
Suit was for declaration of right, title, and interest about the suit property and recovery of possession in the suit property.
Achha. Yes.
Your Lordship, I prepared a note and I am placing.
Please. Yes.
Your Lordship, the case of the plaintiff was that he had purchased the suit property from Abhimanyu Behra, son of Arjun Behra, through register sale deed on dated 24th May 1990 by exhibit, and he was possessing the same by mutating the said property in his name. But the defendant number 1 and 2 forcibly took the possession of the same on dated 11th April 2006.
Civil possession mane?
The disputed land, which was brought by the plaintiff, he had muted the same and he was keeping the possession. But defendant number 1 and 2, it was they forcibly took the possession.
Forcibly possession mane kon? Badai ki posile na kon kole?
No, they just entered to their suit property and took the possession.
Okay. All right. Then so you filed the suit.
Yes, my lord.
Yes. Then
Then the plaintiff filed the suit in the trial court against the defendant number 1 and 2, and he prayed for declaration of his title over that suit property and recovery of possession. The trial court dismissed the suit on the ground of non-implementation of necessary parties. The defendant number 1 and 2 contestant had objected in the written statement, and their main plea was that the suit is bad for non-joinder of necessary parties, because the suit properties are joint and undivided joint family properties of Abhimanyu Behera along with his sister and 2 other persons.
Abhimanyu Behera is the vendor of the plaintiff.
Yes, my lord.
So how are defendant number 1 and 2 related to that Abhimanyu Behera?
Arjun Behera has 4 children. Abhimanyu Behera, Draupadi Behera, Asal Behera, and Almani Behera. Draupadi, the defendant number 1 was the husband of Draupadi, and defendant number 2.
Genealogy kahi hai apna? Genealogy gote kagaj re tiyari kale? Yer mentally mu bujhibi jinsa taku. I will picture it mentally.
Pardon me.
No, that is the first mistake. Don't be sorry, Farad. You are learning, don't worry. But the first thing is that genealogy. It is a very logical thing. If you keep on saying, say, Parvati ro Swami thila say Subhadra ro Bhoni thila Amoko, the court will imagine. You have a document. The court will immediately see and capture the essence of it. Anyway, so they are related to that Arjuna Behera. So they say that it is a joint family property.
It stand recorded jointly in the name of 6 persons.
No, apna mutate kole, the plaintiff had mutated it. ROR was issued.
But my lord, mutation does not create or extinguish.
No. Property was recorded in your name, isn't it?
Like the trial court in its para 6 has clearly mentioned that the joint exhibit under exhibit B, the suit property stands jointly recorded in 6 persons.
So you never
6 persons.
You have said that you possessing the same by mutating the said property. After purchasing it from Abhimanyu Behera, you mutated it in your name and you have been possessing it. That is what you say. So now when you say that it has been recorded in somebody else's name.
Plaintiff possess the same by mutating the same land in his own name.
Yes. So.
But the suit property stands jointly under exhibit B. The plaintiff under exhibit 2 has not produced the original cell deed. It has produced a certified copy of the cell deed. But under exhibit B, it stands jointly recorded in the name of 6 persons. Therefore, the trial court dismissed the suit on the ground of non-joinder of necessary parties.
Okay. So what were the issues? Whether the suit is bad for non-joinder of necessary parties or the sale. So issue number 4. Let us see. What is the finding of the trial court? The plaintiff business plaintiff has stated that the
Your Lordship, the first appellate court is not correct.
Just a moment. Let us see the first trial court order under issue number 4. Exhibit 2, perusal of the contents of the certified copy shows that the suit land stands recorded in the name of Abhimanyu and others. Thus, the exhibit 2 categorically reveals that Abhimanyu is not the sole owner of the suit land. Further, in this regard, the defendants relied upon the document they filed certified copy. No. So he holds that the recorded tenants have not been made parties who are necessary parties, therefore non-joinder.
Yes, ma'am.
What about sale deed?
The sale deed was a certified copy, not an original one.
What was the finding of the trial court in this regard? About the sale deed?
The trial court mentioned that it was certified copy of the sale deed.
Says therefore genuineness of the sale deed executed by Abhimanyu in favor of the plaintiff is shrouded in mystery. In this regard, it may be noted that the original sale deed has not been produced by the plaintiff. So, appeal was filed.
isn't it? So suit was dismissed.
Yes. But the first appellate court reversed it.
Okay.
The first appellate court reversed it on the basis of relying upon the oral evidence of DW1.
Let us see. Let us see that finding. কোন জায়গায় ফাইন্ডিংটা আছে? So there are basically three findings of the trial court. First is the plaintiff failed to file the original copy of the sale deed.
Yes, madam.
So he could not, according to the trial court, he could not prove that he had purchased the land from Abhimanyu. And second is that non-jointer. Third is Abhimanyu was suffering from mental disorder.
Yes, madam.
Well, so what is the whether Abhimanyu following point?
Jointly in the Hall, it has been clearly mentioned that the suit land along with other lands have jointly recorded. That means the first appellate court also agrees that the suit land has been jointly recorded in other people.
But he holds that there is a prior partition in which that portion which he sold fell to the share of Abhimanyu. That is what he holds.
My lord, the prior, like the partition point is based on the basis of the observation made by the first appellate court by relying upon the oral evidence of DW1. But in the Hall ROR under Exhibit B, the suit property clearly stands clearly stand in the name of 6 persons. So they are the recorded tenants.
No, he holds that there was a partition between Abhimanyu and his sisters. Therefore, it cannot be said that the properties are the joint family properties. So he disbelieves the evidence.
Yes, ma'am.
What is wrong in this?
My lord, first thing, they have not, the partition was not in meets and bounds. And the distribution cannot be made behind the back of some recorded tenants. In the present case, the suit properties were being dealt behind the back of Draupadi, Asal, Almoni, Jatri, Bhimo, which is illegal. And in the plaintiff.
No, you are a stranger to the family.
No.
Then how are you related to the family?
I am the husband, the dependent number 1 was the husband of Draupadi, who is the sister of Arjun.
Achha.
And who's sister of Abhimanyu and daughter of Arjun. And the later one was the son. That means they are the successor of Draupadi.
Okay.
They have some sort of right and interest in over the suit properties.
Okay. All right.
The plaintiff himself has admitted in para 4 and 6 in the trial court judgment that the suit property has not been distributed among the recorded tenants and they were combinedly having 16 decimals of land, which the trial court has observed at the end of paragraph 6 of its judgment.
Therefore, from 16 decimals of land, Draupadi was allotted with 4 decimals. So she has got no right so far as the balance 12 decimals of land is concerned. Now, trial court, while deciding issue number 5, after taking into consideration the entries made in the ROR, so he reverses the finding of the trial court that it is a joint family property on the basis of
oral evidence.
Oral evidence. Maybe. Unless you satisfy the court that this finding is contrary to the evidence or that such a finding could not have been arrived at on the basis of the evidence, then why should the court interfere with the finding of fact?
And yet the first appellate court did not consider the Exhibit B.
What is Exhibit B?
On Exhibit B clearly states that the suit property has not been partitioned. It stands jointly recorded.
It has been jointly recorded.
Also, my lord, another point is they have not produced the original copy of the sale deed. They have produced the certified copy
That
of the
is
sale
true.
deed.
That is true. That is one aspect which we will go to the later. What will be the effect of non-production of the sale deed by the person who claims to be the beneficiary under it. So that is a valid point. But only because the property stands recorded jointly in the ROR, can it be said that there is no partition?
Yes, my lord. That means there is no partition. Without partition, or Abhimanyu had no right to sell specific portion of shoot land to Ivan Bera, that is the plaintiff.
When was the sale deed executed? 1990.
Yes, sir.
And you never took any steps to have the deed cancelled or nullified?
No.
Yes. Then
My lord, our sole ground is due to non-gender of necessary parties, the suit is liable to be dismissed. And also for not producing the original copy of the sale deed, it is also liable to be dismissed on that ground also.
Solid. We'll continue tomorrow. କାଲି କି ଆଉଥରେ ଲେଖିଦେବା ପାଠ ଟିକେ ରହିଲା କାଲି ଲେଖିବ tomorrow again we'll continue because I've heard you. I need to hear the other side. I've seen the substantial questions of law.
Yes, ma'am.
Whether the first appellate court was justified in relying only upon the evidence of DW1, and secondly the original non-production of original sale. What is the law in this regard? What have you researched?
My lord, for non-production of original sale deed, it has to be proved in accordance with law. That means under section 65C of the Evidence Act. And there is a case law called Roman Catholic Mission versus State of Madras. It has been held in this case law that foundation must be laid for the reception of secondary evidence. If the court has accepted it as a secondary evidence, it must have laid some sort of foundation that where the original document is gone, either it is lost or what happened to the original document. In this case, there is no foundation has been laid.
What has the plaintiff said about it in the plaint?
Nothing. Nothing. The plaintiff said nothing.
Okay. Okay. All right. We'll continue tomorrow.
Obliged.
Mr. Jana will continue tomorrow.
Right.
Let the other side will give another opportunity.
ମୁଁ ଆଜି ଆଉ ଥରେ
କୁହନ୍ତୁ ଏଟା ମାନେ ଯଦି ସେ appear କଲେ ଭଲ କଥା ନହେଲେ we close it.
copy of the note of submission has been served.
Yeah, that is what I'm saying. Yeah, the endorsement is there. But if it is not there, okay. But once it is started, ମାନେ ଏଟା ସରିବ.
ଆଜ୍ଞା
ଆରମ୍ଭ ହେଲା ମାନେ ସରିଯିବ. I will not wait for କାଲି ଯାଏଁ wait କରିବି ଯେହେତୁ ଏଟା weekly list I will ମାନେ finally I may keep it for judgment on close it on Friday. But I'll give him opportunity. ପୁରୁଣା matter କାଳେ ଆପେ ପକ୍ଷ ସାଙ୍ଗରେ କଣ୍ଟାକ୍ଟ ହେଇନଥିବ କଣ ହେଇଥିବ. Yes.
Item 42.
I am appealing for the respondent.
Yes. Who's for the appellant?
Lordship, I'm requesting for one passover because senior counsel Mr. Prafulata was
Passover. Passover for the day.
Kali.
Yes, it will be called out again, Mr. Tripathi.
Item 43.
Item 43. Your matter, Mr. Rao.
Yes, ma'am.
You are the appellant.
I am the appellant.
Okay.
Plaintiff.
Yes, that's all right. No, your name is not there. That's why.
Name is not reflected. Last time, Millard, your lordship recorded my name and.
No, it's all right. That is not an issue at all. I just wanted to make sure that you are appearing in the right case. Yes, the order sheet mentions that you are appearing.
Mentioned and memo.
You are appearing with Mr. G.N. Sahu.
Right.
Yes. All right.
Millard,
let me just look at the substantial question.
The appellant against reversing judgment.
A very interesting question. Reversal.
Millard, though it is mentioned reversing judgment, Millard, almost the finding of the trial court in my favor completely accepted, but abruptly it is mentioned that the suit property, but suit property it will not
So
apply.
it's a reversing judgment.
Reversing judgment.
All right. Let us see the.
Let me submit the.
Yes, please.
Millard, the plaintiff filed the suit
Yes.
for a declaration that she is the only successor of the property. And second prayer is that the adoption, alleged adoption made by the Sumitra is not valid.
Yes.
The trial court found that both the grounds taken accepted. She was declared she is the only legal heir of their mother Sumitra, and she inherited the property of the Sumitra. Second, Millard, the adoption claimed by the defendant number 1 is not valid. It is not accepted. Appeal filed by in the appeal, Millard, the adoption was same, that is confirmed. That means he is not adopted son. And the finding of regarding the succession, she is the only heir to succeed the property of her mother, Sumitra. But while holding that, he held that it will not apply to the suit property. That is, Millard, without any discussion, without any material, abruptly has mentioned that. The facts, Millard, that one Lakman is the recorded owner of the property. And he has a son called Prahalad. And Lakman died, Prahalad inherited the property. And thereafter, Millard, the Prahalad died. Sumitra is the widow. She inherited property. Her name was recorded.
Sir, can you please repeat? I just missed it. So, who is Sumitra?
Sumitra is the widow of Prahalad.
Widow of Prahalad.
Widow of Prahalad. After death of Prahalad, the lands were recorded in the name of Sumitra in all settlement, and she was enjoying the property. In 1984, she remarried, got a child, that is the present plaintiff. In 79, Millard, defendant number 1 claimed as a adopted son, got the lands mutated in his name. When she could know, Sumitra could know about this, she filed appeal. Appeal was dismissed. Thereafter, she filed a suit for declaration. Suit filed by that time Sumitra also died. Suit filed by the present appellant for a declaration that she is the only legal. Appeal filed, Millard. In appeal also, the finding of the adopted son was confirmed that he is not adopted son. And also held, Millard, Sumitra is the legal heir and succeeded the property of mother. But while giving finding, confirming the finding of trial court, only she please, but it is not applicable to the suit property. That is under challenge before your lordship. Ground number A is the your lordship, can page 6.
Page 6 of the
appeal memo. Grounds, your lordship.
Yes.
Whether the judgment of the land lower appellate court that the property inherited by the Hindu female from her first husband shall revert back to the legal heirs of her first husband and not to the issues of the female born through second husband is vitiated in law, being contrary to section 15(2)(b) of the Hindu Succession Act.
Have recently you delivered a judgment on this aspect?
Yes, recently, Millard.
Very recently.
Now the point is clear. It is accepted by the different high courts and also Supreme Court. Millard, the facts, Millard, there is no dispute. There is no dispute about the facts.
So
And adoption,
if you mean-
adoption, both the courts found that is not, adoption is not valid.
that is all right.
So that goes. Only thing, even second finding, Millard, both the courts held, she is the legal head of Sumitra and she is successor of the property of Sumitra. So that to that extent it is clear. Only question is the suit property, she will not succeed the suit property. That is, Millard, only for this interpretation of section 15 of Succession Act is the only question, Millard. Your Lordship kindly says that section
Hindu Succession Act.
15, 1 and 2.
Hindu Succession Act.
Hindu Succession Act. Question is, Millard, Hindu section 15(2)(a)
Yes.
deals with the land inherited from the father and mother. 15(b), Millard, the property inherited from the husband,
Father-in-law.
Father-in-law. Now, admittedly, there is no dispute about it that she is inherited, the mother inherited the property from the husband, Prahalad.
So B applies.
So B applies. And also regarding Millard, the question, if there is no issue, here Millard, Prahalad and Sumitra has no issue. So Sumitra, Millard, enjoyed the property recorded in the name of Sumitra and her mother-in-law. That Khata number 65 and 67. 65 recorded in the name of Sumitra and mother-in-law Jambavati. And 67 recorded in the name of Sumitra. These are no disputed fact. And only the claimant is Millard, defendant number 1, on the basis of the
Adoption.
That is disbelieved by both the courts. So,
and that has not been challenged.
That is not challenged here. And regarding that Sumitra and this present appellant is the legal head and succeeded the property of the Sumitra, that is also not challenged. That is also not challenged. Those things are confirmed by both the courts. Only question is whether the plaintiff inherit the property. Being a daughter of second husband through Sumitra, is entitled property. That is the only.
I have dealt with it exactly the same point very recently in a judgment.
Millard?
I have dealt with this very same issue where the widow remarries.
Yes.
So there the court had relied upon erroneously under to section 24.
Yes.
I said I have taken a different view. I said in that particular facts of the case that even if she remarries and the children born to her will be entitled to in view of the language employed in section 15. Very recently, probably last week, I filed.
And that another Millard.
Judgment
Raghuveer Das.
judgment you recently ଦେଇଥିଲେ. Mr. Rao, should I refer to my judgment to, should I?
Not.
I'll ask. I'll ask your
Lordship.
You find out from
Raghuveer Das, Justice Raghuveer Das, given a judgment in 2014, analyzing all the High Court judgment and Supreme Court's Bhagat Ram judgment and other judgment, and held, even he has gone to the extent, if the child born to the womb of mother, natural son, and also second wife, second husband, even they are also coming within the succession. And that case, Millard, the natural daughter through first husband, given the succession, though the property belongs to the second husband, which he was inherited. Second husband property inherited, that is given, so that declared that first natural daughter also entitled to that. Has gone to that extent. That is 2014. That is also reported. I will also see your lordship. This is the gist of the case. If the question of law is Millard,
I've seen it. I've seen the question of law has been framed.
There is no Milord, the 15.2 A and B says, if no legal age, no person born to the either inherited, the property which has come from the source, it will go to that.
It will revert back.
Revised. But here is Milord, second husband.
He has children.
Child. So it is very
Oh, he
clear.
has a child rather. So this is exactly what I have dealt with.
That portion of even the lower appellate court, Milord, that is dealt with that. But abruptly somehow he said that is not applicable to the suit property. That is the
My judgment was rendered on a slightly different fact, but the principle was the same. There the widow, the plea was taken.
Number of decisions,
has taken a plea that since the widow had remarried, her children born out of the second marriage will not be entitled. I did not accept it. Relying upon a Bombay High Court judgment, I probably that Supreme Court judgment was not cited before me.
That Bhagatram and the other Supreme Court decisions also there. Milord, I will go through. I have not.
Yes. It maybe.
This is the question, Milord. Let him answer.
Yes.
Your Lordship, I am appearing on behalf of Mr. Ratta. My learned senior will argue the matter. So kindly grant an adjournment.
All right, we'll take and call it tomorrow. This is in the list.
Argument also I have prepared. I will give it, Milord.
Yes. No, tomorrow.
But I will see the meanwhile that
I will. You please contact the court master. He will give it. We'll call it again tomorrow for his reply.
Yes.
Password.
Item 44.
Item 44.
Praying for an adjournment.
Why? 2015 matter. Why adjournment?
Sir will argue this case.
Why don't you argue? Why?
Sir asked me to.
So what? I am asking you to argue. Otherwise, I'll dismiss the appeal.
Lordship may pass over.
No. Why pass over? Why are you not arguing? Why are you not ready?
Certain.
All right, pass over.
Pass
over. छोटिया जिनसटा खाली येते रे टाइम फॉर रेस्पोंडेंट answer about my ancestors.
Tomorrow.
One request.
Yes.
Okay, I was on my legs in fact.
Yes.
Item 36 टा मु प्रिपेयर हेकि आस्तिली करिया पे ए मैटरटा जेहेतु रहिथिल चालिथिला म आसी नथि करदि परिबि जदि कहि एडमिशन
पर या पूर्व आ गोटे मैटर थला मिस्टर कि सीए राव
करथला आउटसाइड काउंसिल अछंती सी आसले हबो ताकु न आसिला करिया से पढिले
स्टेट काउंसिल को
आगे
no Mr. CA Rao was appearing in that.
हां से तेनु सेथरा
tomorrow that will be called out tomorrow.
Sir 36 टा नहीं फ्रेश एडमिशन किछ नहीं
30 fresh ticket one. Let me complete the list.
आगे
Item 45.
Pass over.
Item 46.
In item 46.
46.
Lord, I am for the respondent. My friend is...
Yes, Mr. Mishra.
My your lordship can grant me 10 days time. This has come after in the month of March. This was admitted. Notice was issued. My lord, I have not been able to get instruction. I was praying for 10 days time.
Yes, Mr. Mishra, what do you say?
My friend is sought for adjournment.
All right. As requested by learned counsel for the appellant, list this matter in the week commencing 29th July.
Yes.
Item 47.
Item 47 I am for appellant. Admit is there appear kari jaychanti.
Week commencing?
Next week.
Yes. Item 48.
Item 48.
I was
Matter. Item 50.
Therefore, next week.
All right. In the week commencing?
15 July.
15 July.
Item 52.
Hey, 51 ta? Oh, Arjun hai 52.
51.
51 has been adjourned.
Right.
52. Yes, anybody? Pass over. 53, Mr. Author? No, it's not your matter. Yeah, yes, 53 is your matter. We commencing?
Next week, December. 53 days, huh?
29 July.
My lord, 52, they have asked time. I am for the respondent. Appellant, they have.
Fine.
Telephonical, they said that.
No, telephone के लिए कौन मत telephone कर से ना कौन मो पाकर टाइम मांगले टाइम दबा लो कौन हो आपन telephone मांगले कौन है मोर इट का telephone नहीं item 54
Item 54.
Your Lordship, I'm on the behalf of petitioner, my learned senior Mr. J.R. Das is on accommodation, Your Lordship. Completely.
कर दियो ओके वो अभी तो पता कौन ना we commencing 20th August.
Yes, sir. Obliged.
Item 55.
To continue.
I'm for OP2 Lodge. Item 54 sir जी हाँ लखो पास होता 36.
Your Lordship, interim order in item number.
Interim order to continue.
Obliged.
So item number 36.
The last one. Huh? Yes, this is for admission.
It's only for admission, bro.
Yes, कौन है जी?
The defendant is in appeal. Defendant, yes, defendant number 1 and 3, they're in appeal. Defendant number 1 and plaintiff, I mean, the defendant number 2's wife and plaintiff, they are brother and sisters. One brother and
Defendant number 2 is Gauranath Naik.
Gauranath Naik, he's dead. His wife was sister of Amulya Naik, plaintiff's sister. Correct, man?
His wife was? He has died.
Gauranath Naik is dead. See, the sister is also dead. But then Amulya's sister and Gauranath's wife, they are brother and sister.
Okay.
Now the suit is filed for declaration of right title interest and recovery of possession. Trial court decreed the suit based on a sale deed. Plaintiff says that our father is Madhu Naik. In the year 1981, his sister Puspa executed a sale deed in favor of defendant number 1, executed a sale deed in the year 81 in favor of defendant number 1, showing that father Madhu Naik is dead and Amulya is minor. On that basis, the sister's sale deed executed by sister is completely void ab initio. That is how we challenge the sale deed. Now, after the decree was passed, we filed an appeal. Now, appellate court passed a peculiar decree. Appellate court says, partly with regard to the death and other aspect, after giving finding, passed a decree for partition, saying that the sale deed is not completely void to the extent 2013 Supreme Court. To the extent करिकरी एक्सेस टाकू 3/8 कर देकरी ब्रदर हाफ करिकरी यार 1/3 कर देचन. That is how that.
What was the finding of the first appellate court regarding the sale deed?
Sale deed is, they say the sale deed is not void completely. To the extent her share is concerned, that is valid.
Okay.
That is how the appellate court says. Now, my point is, plaintiff filed the suit, plaintiff himself has not come to lead evidence because death of his father was in his special means of knowledge.
Is that Order 18 Rule 1?
Right. He has.
I remember.
Yes.
Somehow
he has to give himself, turn to the witness box and give evidence. But I have framed.
Just a moment. Let me just refresh my memory.
Sir, এইটা আপনারা দেখে দিন তো এই যে
Order 18 Rule 1. Yes, right to begin. The plaintiff has the right to begin only with the defendant.
Yes.
So, a lot of decisions,
I have got it.
adverse inference can be drawn.
Got it. Here is the decision. 99 Supreme Court.
I know. Okay. So, what are the substantial questions of law? Let us see.
Sir, ଆଉ ଗୋଟେ କରିଛି ଏଥିରେ ସେ ଲିମିଟେସନ ପାର୍ଟ ବି ଅଛି 81 ସେଲ୍ ଡିଡ୍ 2015 ରେ ସୁଟ୍ ଫାଇଲ କରିଛନ୍ତି।
So we can A and then B.
Yes. ସେ ଦିଟା କରିଦେଲେ ବାକି
A B ହେଇଗଲା ହେଇଯିବ
ଆଜ୍ଞା
ନାଇଁ? Heard Sri Prafula Kumar Ratha, Learned Senior Counsel with
Sai Brata Rath.
Sai
Brata Rath.
Sai Brata Ratha for the appellant. To the appellants, Bodhi. Appellants peruse the interim judgment, the judgments, considering the submissions and the grounds raised. Grounds cited will come. The second appeal is admitted on the following substantial questions of law. Page 19 to A or B. Hello? Issue notice to the respondents. Gotti jane respondent ଅଛି.
ଗୋଟିଏ ରେସ୍ପଣ୍ଡ
Respondent ଦି ଅଛନ୍ତି. ଜଣେ proforma ବି ଅଛି.
ଗୋଟିଏ ଆପେଲେଣ୍ଟ ଗୋଟିଏ
So,
ଆପେଲେଣ୍ଟ ଗୋଟିଏ
so we will, is Annapurna Sahu required to be noticed?
she has filed written statement with me. We have joint written statement.
So, no conflict of interest. So notice need not be issued?
Need not be issued.
Yeah. Notice we issue notice only to respondent number 1 by registered post with AD. Issue notice to respondent number 1 for the time being. By registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter.
Do you commencing 9th September?
9th September 2024. Yes, what are you?
Final
Okay.
ପଳେଇଲେ ପଳେଇଲେ ଯେ ଆସ
କଣ କିଏ କହିଲେ